All right, so we are currently streaming. In that case, would all parties please raise your right hand? Or at least the witnesses here. And please indicate by saying, I do, if you swear to abide by the rules of this proceeding and conduct yourselves in a manner that is honorable to this forum.
I do.
I do.
And I will assume from what I see from lip reading that people say I do, even if they are not off mute, which thank you, I appreciate that. We are now calling case number 082263, Cam Donaldson versus Karen Basia. Are there any housekeeping matters which the court needs to attend to?
Yes, Your Honor. Your Honor, prior to proceeding, the plaintiff side has a few preliminary matters as well as some motions in limine to be heard outside of the presence of the jury constructively.
Okay, please proceed with those issues.
Yes, Your Honor. Your Honor, it is our understanding that the federal rules of evidence as well as the federal rules of civil procedure are in effect in this trial today.
That is correct.
Additionally, Your Honor, we expect that both parties throughout the proceedings will make objections. We ask to constructively approach, but remain in our position so that the jury can benefit from hearing our argument.
That request is granted.
And finally, Your Honor, what exactly is your preference on tendering experts? Would you like us to lay the foundation and then tender them, or lay the foundation and have them go into their expert testimony?
I would like you to lay the foundation, then tender them, at which point I will offer the opposing side an opportunity to voir dire, should that be necessary.
Yes, Your Honor. And Your Honor, with that, we are ready for motions in limine.
Anything from the other party?
Your Honor, we have no housekeeping. However, we have one stipulation and two motions in limine today.
Okay, then we will address those during our motions in lim. Would the plaintiff like to address their motions in limine first?
Yes, Your Honor. Your Honor, the plaintiff moves to exclude any and all hearsay testimony that the defense will try to enter through their witness, Chris Renard. Your Honor, if Ms. Renard testifies consistent with her report, she will testify as a fact witness as to what other people told her for the purpose of proving the truth of those statements. So at most, or all of that testimony is inadmissible pursuant to Federal Rule of Evidence 801 as hearsay.
Response?
Yes, Your Honor. Pursuant to Rule 703, a witness can use otherwise inadmissible testimony or evidence as long as it pertains to their conclusion. In this case, the defense expert is testifying after conducting a forensic analysis on Lou Donaldson's will. For them to testify about the police investigation, they won't give any opinion-based testimony, but to testify about those facts is admissible under 703.
May I be heard, Your Honor?
You may, briefly.
Your Honor, if this witness testifies consistent to their report, this witness will explain that they were hired to talk about a payout for a $5 million life insurance. If they wish to tender them as an expert in that, we can stipulate that. However, as to investigations on what other sheriff office, what the sheriff office has looked into, or what other individuals have looked into, then they should have called those as people to testify here today, not this individual. Therefore, this is considered a hearsay, and we ask that you exclude all hear testimony regarding the investigation from Ms. Renard.
May I respond?
No, I'm actually going to deny that motion at this time and reserve a ruling for later. The parties are free to address that one as the issue comes up during testimony. Are there any other motions in limine?
With that, Your Honor, the plaintiff is ready to proceed to openings.
Are there any issues from the defense?
Yes, Your Honor. As I mentioned before, we have one stipulation and two motions in limine to bring today. First, I'll start with the stipulation. It has been stipulated by and between counsel that any evidence, testimony, or argument about my client's previous misdemeanor when she was 17 years old, there will be none of that.
Response?
Your Honor, we have stipulated to that.
Okay, thank you. And I do have to interrupt the proceedings very briefly. Ms. Baxter, do you have any conflicts that you need to announce before we continue? And I apologize that we got started without you here.
Thank you, Your Honor. I don't think there is, unless I need to identify the school that I'm associated with.
No, I believe that's already been addressed.
I think so too. No other conflicts, Your Honor.
All right, in that case, we will continue on. So there is the stipulation. There is one additional motion in limine that you mentioned.
Two motions in limine, Your Honor.
Thank you.
Yes, Your Honor. For the first motion to eliminate, the defense moves for the exclusion of the video and transcript of the video of a man named Exotic Bob. By way of background, Exotic Bob is currently incarcerated. He blames the defendant, Miss Baja, for his incarceration. And in this video, he makes accusations against our client that constitute hearsay. Both the video and its transcript are hearsay within hearsay, which is inadmissible at trial and therefore should be excluded.
Response?
Yes, Your Honor. In regards to the video, Your Honor, we have no intention of going into the video. However, we do intend on reading the transcript. Your Honor, pursuant to local rules and stipulations presented to us, specifically stipulation number 4, we are allowed to read the transcript of Exotic Bob. And Your Honor, in response to the hearsay argument, the statements that we anticipate reading in, it will be the last paragraph of the first page of Exotic Bob's testimony. In this paragraph, there will be mention of what Karen Baja stated towards Exotic Bob. This is admissible pursuant to party opponent, Your Honor. Additional to that, what Exotic Bob will be talking about was prior actions that they've done together, and this will be a statement against their own interests, as Exotic Bob will talk about how he was dealing with illegal activity with the defendant, and this sheds a light that he would be liable to criminal or civil liability. Therefore, this does not fall under hearsay, Your Honor.
May I be heard, Your Honor?
Briefly, yes.
This document still constitutes hearsay within hearsay. What has been stipulated to is that Exotic Bob is an unavailable witness. If if they're trying to bring in Exotic Bob as a statement against interest, they are going to be offering this for the truth of the matter asserted. They're going to be offering it as the truth. For it to be a statement against interest, it has to be against the interest of the person who is admitting the statement. And here, this is not against the person who is admitting the statement. Additionally, should Your Honor find that that you will allow for the admission of this video under Rule 106, the best evidence rule, we would argue that the video itself comes in rather than the transcript. This way, you can see the way Bob Exotic acts, his expressions, and who he is, because that is part of the testimony. And therefore, as the best evidence rule, it is important for the jurors to see that video if you are going to admit that, so that they can assess the credibility of the character of Exotic Bob himself.
At this time, I'm going to deny the motion in limine pursuant to 804A. I do believe that this is an unavailable witness, and also pursuant to stipulation number 4. Your next motion in limine, please.
Yes, Your Honor. Your Honor, we are seeking the redaction of a document as it is hearsay. Would Your Honor like to see the document displayed on the screen so you know what I am talking about?
Please.
Mr. Nanavati, could you please put the temporary restraining order on the scene? Now, Your Honor, we are seeking the redaction of this document. By way of background, the document is of a temporary restraining order that Lou filed against our client, Karen Baja. In this document, Lou gave 3 reasons for filing the order. And while we acknowledge that the second 2 do have some hearsay exceptions that they fall under, the first is hearsay within hearsay, and therefore it is inadmissible at trial, and we ask that it be excluded.
Response?
Yes, Your Honor. Your Honor, in regards to the first statement that has been redacted, that statement reads, Karen Baja, defendant, has threatened to kill me. Your Honor, this goes to admissions of opposing party, as the threats that are being mentioned are coming from Karen Baja. Second, Your Honor, as for the other hearsay argument, this shows the effect it had on the listener. Had it not been for these threats, then this individual, Mr. Donaldson, would not have applied for this restraining order. Therefore, this is not hearsay. And then as for the last portion, the second portion of the last statement, it reads, I do not feel safe around Karen Baja. Thank you, opposing counsel. Your Honor, this shows the then existing state of mind of Mr. Donaldson. It's important for this jury to have the complete document. They cannot view this evidence in a vacuum. They need to understand why this restraining order was applied for. They need to understand who Mr. Donaldson did not feel safe around. Therefore, we ask that you deny the opposing counsel's motion.
Your Honor, may I be heard briefly?
I'm going to interject and say I'd like to know why any portion of this document should be admitted. So counsel, if you want to go ahead and start off with that, I am definitely disinclined to introduce or allow the introduction of the entire document, but I would like to know if there is some redaction that is agreeable to the parties and, more importantly, agreeable to the court.
Yeah, sure. Your Honor, in response to why this should be allowed in, or the relevance of it, Your Honor, this piece of evidence is crucial to today's case. Your Honor, the defense will stand before the jury and have the jury believe that Mr. Donaldson signed an alleged will and testimony, signing everything he ever owned to the defendant, Karen Baja. Your Honor, they are expected to believe that he signed that will 2 days after this restraining order was filed. They need to know how there was a restraining order, and then 2 days after that, they're expected to believe that then the same individual that attempted to get a restraining order on the defendant then gave everything away to her. Your Honor, if we were to exclude this from the jury, they'd be viewing this evidence in a vacuum. They'd be viewing the case in a vacuum. Therefore, this is highly probative and is not substantially outweighed by any prejudice that opposing counsel has mentioned. Your Honor, in response to redactions, if Your Honor would be inclined to allowing this, and if there are redactions, then we could stipulate to the first statement being redacted.
Response?
Your Honor, yes, that's what we were seeking with our motion in limine. We believe that the first statement should be redacted, as it is hearsay within hearsay. If Your Honor does feel so inclined, this document, we wish this document to be excluded under 403, as it is this evidence can outweigh the unfair prejudice of the jury, and therefore should be excluded.
At this time, I do feel that the probative value is outweighed by the prejudicial impact of a document such as this, even with the redactions proposed. So I'm going to exclude this document this time. If there is a response where you need to bring this up for a different reason, I will be happy to address that outside the presence of the jury later on during the trial.
Yes, Your Honor.
Your Honor. And with that, the defense is also ready to proceed to trial.
Will the plaintiff then proceed with her opening statement?
Yes, Your Honor. May it please the court, counsel, members of the jury. The first rule of nature is self-preservation. In today's trial, you're going to learn that the defendant, Karen Baja, conformed to only one law, the law of self-preservation. You're going to learn that the defendant only cared about one person, herself. Now, in order to understand how all of this applies to today's case, we need to go back. We need to go back to the early years of this defendant's life. You see, it's at this point in time that the defendant, well, she doesn't have much to her name. She isn't born to a wealthy family, but one night, everything changes. She meets millionaire Lou Donaldson, and at first, it's like a dream. They soon get into a relationship, and after that, they eventually get married. Mr. Donaldson even offers the defendant an opportunity to run his own family business, Wild Wild Life, which is a big animal sanctuary, and he allows her to enter that family business. You see, in the defendant's mind, she believes that Mr. Donaldson is her Prince Charming. She gets to leave her old life behind and spend the rest of her days in a castle. But members of the jury, what was once a dream for the defendant, what soon became a nightmare for Mr. Donaldson. If you fast forward to June 2012, you're going to learn that one thing changes and one thing stays the same. Mr. Donaldson, he now wants to part ways from Miss Baja, but she still wants everything. You see, this is an important event, and you need to keep this in mind because this is what sends the defendant's life upside down. It's at this moment that the defendant realizes that she's being kicked out of her castle. It's at this moment that she realizes that she needs to look out for herself. And that's exactly what she does. Jury, a couple months after Mr. Donaldson mentions this to Ms. Baja, he suddenly disappears. Now 5 years have passed and no one, not a single person, has seen or heard from Mr. Donaldson. Members of the jury, you're going to learn that in this jurisdiction of Statesville, you need to wait 5 years in order to have someone legally declared dead. And today, you're going to hear that this defendant rushed to the courthouse and had Mr. Donaldson legally declared dead just 1 day after his 5th year anniversary from his disappearance. Now, members of the jury, you don't have to take my word for any of this. No, we're bringing you 2 witnesses. These are people who are currently living through this nightmare. The first witness that we're going to present to you is Cam Donaldson. Now, that's Mr. Donaldson's daughter. And listen closely to when she explains to you the last few months of her father's life. Listen to the threats that she heard the defendant make. Listen about the last exchange she ever had with her father. She'll tell you how she was locking up from work, and when she turned around, she saw her father. And so they begin to converse, and they begin to make up dinner plans for that coming weekend. And so as that conversation draws to an end, well, she waves goodbye. She says, "See you at supper, Dad." Members of the jury, that supper never happened. A couple nights after that conversation happens, an alarm goes off. So Cam Donaldson, well, she hears this alarm as she rushes towards Wild Wild Life. She's thinking to herself, what went wrong? Did a tiger escape? Is there an intruder? So she heads straight to her office. And outside of her office, she finds a man with bolt cutters. And next to that man is the defendant, Karen Baja. And in her arms, she's holding a lockbox. And inside that lockbox is the last will and testament of Mr. Donaldson. A few days later, the defendant was left in charge of Wild Wild Life, and Cam Donaldson was fired. Why? Because the defendant was looking out for number 1, herself. Members of the jury, we're also bringing to you an expert in handwriting analysis and investigation. This expert's name is Taylor Pride. Now, Mr. Pride is going to explain to you about mysterious facts surrounding Mr. Donaldson's disappearance. He's going to explain to you about different threats. He's going to talk to you about an alleged will that the defendant claims Mr. Donaldson signed. Now, I want you to pay close attention to when he talks about this analysis that he makes. Members of the jury, you are going to be walked through that same step-by-step analysis, and you're going to come to the same conclusion that Mr. Pride did, that will is forged. Now, members of the jury, as the plaintiff, the burden lies with us at this table, but we don't see it as a burden. No, we see it as a responsibility, and one that we will fulfill. And that responsibility is to prove to you all by a preponderance of the evidence, which simply means more likely than not, that the defendant, Karen Baja, intentionally or recklessly, wrongfully caused the wrongful death of Mr. Donaldson. And after all of this testimony is presented to you today, after all of this evidence, my co-counsel, Jasmine Matier, will stand before you, and she'll review all the evidence that you heard, all of the facts. She's going to present to you a verdict form. And she's going to ask you to come to a verdict that is consistent with the truth, a verdict that is consistent with your own common sense, a verdict finding this defendant liable because she is.
Would the defense like to make an opening statement?
Yes, Your Honor.
Thank you. You may proceed.
May it please the court. This is not a case about a murder. This is a case about money. This is a case between a wife and her stepdaughter over her missing husband's $10 million inheritance. You see, when there's family disputes over a large amount of money, things can get ugly pretty quick. This case is a perfect example of just how ugly family disputes over money can get. You see, the plaintiff, Cam Donaldson, has brought her own stepmother, Karen Baja, into court today and is falsely accusing her of murder. You're going to learn that at the end of the day, this is not a case about a murder. This is a case about money. Now, to understand how we got here, I need to take a step back to August of 2012, when a man named Lou Donaldson disappeared. When Lou Donaldson disappeared, he left behind two very important people in his life. His wife of 20 years, a woman named Karen Baja, and his stepdaughter from a previous marriage, Cam Donaldson. 2012 was a year that drastically changed both Karen and Cam's life. Neither of them would ever speak to or hear from Lou Donaldson ever again. But what you're going to learn today is that for the next 5 years, Karen and Cam went about their daily lives until 5 years later in 2017, when everything changed. You see, in 2017, 5 years after Lou Donaldson disappeared, Cam Donaldson finds out that Lou has left his entire $10 million estate to his wife. Cam Donaldson finds out she won't be receiving a single penny. Cam is furious. That anger grows into resentment and hatred. And with her father out of the picture, there's only one person who she can direct that anger towards. And that's the defendant. And how does she direct that anger at Karen Baja? By falsely accusing her own stepmother of murder and filing this lawsuit for $10 million. This isn't a case about murder. It's a case about money. My co-counsel, Ms. Bridget Fasano, and I represent Karen Baja today. Karen Baja is the owner of a local sanctuary for large cats. You're going to learn that she loves nothing more in her free time than taking care of her animals. Karen Baja is going to tell you how Lou Donaldson is the love of her life. Now, their marriage certainly had its fair share of ups and downs, but Miss Baja loved Lou Donaldson through and through. 5 years after Lou Donaldson disappeared, for the sake of her own closure, Miss Baja asked a local court to change his status from a missing person to deceased. Now, throughout today's trial, you're going to hear a lot of things about Karen Baja. And I am not here to tell you that Karen Baja is perfect. However, at the end of the trial, one thing will be very clear. Karen Baja is not a killer. Now, the plaintiff has brought Karen Baja to court today with a wrongful death lawsuit. And in this country, when the plaintiff brings somebody into court, they've got to prove their case. You see, the defense has no burden. The plaintiff, and the plaintiff alone, has to prove every element of wrongful death to you by a preponderance of the evidence, meaning more likely than not. So the plaintiff has to get up here and prove to you, first, that Lou Donaldson is actually dead, and second, that Karen Baja's reckless or intentional conduct caused the death of Lou Donaldson. So let's talk about the evidence you're going to hear today. But just as importantly, I want to talk to you about the evidence that you're not going to hear today. Not a single witness in today's trial will raise their right hand, take an oath of honesty, and be able to tell you how, when, or where Lou Donaldson died. You won't hear any evidence of an autopsy report confirming any cause or manner of Lou Donaldson's death. That's because nobody has been able to locate Lou Donaldson, dead or alive. Members of the jury, I'm going to repeat that because it's so important. Nobody has located Lou Donaldson, dead or alive. This is a wrongful death case, and you're going to learn that the plaintiff has no idea where Lou Donaldson is. But what you will hear evidence of today is the police report and the police investigation that occurred into Lou Donaldson's disappearance. You're going to learn that in 8 years since 2012, when the police started this investigation, they haven't found a body. You're going to learn that the police are investigating this as a missing persons case, not a homicide. Most importantly, you're going to learn that to this day, the police have never even considered Karen Baja as a suspect. By the end of this trial, it's going to be very clear to you that no, not the police, not Cam Donaldson, not Karen Baja, nobody knows where Lou Donaldson is. At the end of the day, everything in this case comes back to one single person. And that's the plaintiff, Cam Donaldson. You see, members of the jury, you're going to learn that Cam Donaldson is the only person who has ever accused Karen Baja of murder. You're going to have the chance to hear from Cam Donaldson today. And while she's testifying, I want you to pay very close attention to the timeline of her accusations. Cam Donaldson did not accuse Karen Baja of murder in 2012 when her father disappeared. In fact, for the next 5 years after her father disappeared, Cam Donaldson did not accuse Karen Baja of murder. What you're going to learn is that Cam Donaldson only accused Karen Baja of murder when Cam Donaldson found out that she just missed out on $10 million. This is not a case about a murder. This is a case about money. That's why at the end of today's trial, my co-counsel, Ms. Bridget Fasano, is going to come before you and review all of the evidence. She's going to ask you to find Karen Baja not liable. Thank you.
So plaintiff ready to call their first witness?
Yes, Your Honor. Your Honor, the plaintiff calls Cam Donaldson to the stand.
Ms. Donaldson, may I remind you that you're still under oath as you took earlier this session?
Yes, Your Honor. Thank you.
Your
And
Honor,
for purposes of housekeeping, we are going to have the party who is not actually asking questions be muted. If you do need to raise an objection, please unmute, ask your objection, or state your objection, and then we will address that and then move on. Thank you. You may proceed.
yes, Your Honor. Good afternoon. Could you please introduce yourself to the members of the jury?
Hi, yes, my name is Cam Donaldson.
And why are you here today, Ms. Donaldson?
I am here today as a representative of my father's estate and on behalf of my family.
You mentioned your father. Were you too close?
We were extremely close. My father and I were the best of friends. I mean, we spent pretty much every day together. We worked together at Wild Wildlife, and I was his assistant for 20 years.
And what exactly is Wild Wildlife?
Well, it was my father's passion. He loved animals and big cats, so he worked really hard and saved enough money to be able to open up this sanctuary, and he dedicated his life to the animals.
Now, you said that you worked alongside your father at Wild Wildlife. What exactly did you do there?
Gosh, I did absolutely everything. I mean, my father would even joke that I knew more about his business than he did, but I wrote the checks, I managed his calendar, I answered the phones, ordered supplies, and I managed all of the accounts.
And what accounts did you manage specifically?
All of the financial accounts.
Do you still work at Wild Wildlife today?
No, I don't. I mean, like I said, I had worked there for 20 years alongside my father, but then Karen Baja fired me after she took over.
Now, you mentioned the defendant. Who is she to you?
She was previously married to my father before he disappeared.
And when did the defendant fire you?
It was right around the time that she took over, which was about 2 days after my father disappeared.
Let's talk about your father's disappearance. Ms. Donaldson, when was the last time that you ever saw your father?
It was August 17th of 2012 at about 6 o'clock in the evening. It was a Friday and we were locking up shop, closing up the office for the weekend. He had told me that he would see me on Monday, but if I wanted, I could stop by for supper on Sunday.
Your Honor,
that's what I had.
Oh, I'm sorry, what was the objection?
hearsay, Your Honor.
Response?
Your Honor, if permitted to testify, and this witness testifies in accordance with her deposition, she's going to say that her father told her that he would see her on Sunday for supper. Your Honor, this is being used to show the effect on the listener being this witness, Ms. Donaldson. She was under the impression, because of that statement, that she would see her father sometime in the near future. We're not using this statement for the matter of truth asserted.
I'm going to overrule the objection. Please continue.
Yes, Your Honor. Ms. Donaldson, I'm going to ask you that question again. What exactly happened on that last day that you saw your father?
Sure. So like I said, we were locking up the office and he had told me that he would see me at work on Monday, but if I wanted, I could stop by for supper on Sunday, which is what I had planned to do, but that never happened.
What do you mean that never happened?
Well, Sunday rolled around and at about 6 o'clock in the morning, the alarm started going off at Wild Wildlife. I lived very close by, so I rushed over there and the police followed behind me. And when we got there, we saw Karen Baja standing outside with a lockbox, and she had some man with her who I'd never seen before, and he was holding bolt cutters in his hands.
Your Honor, I would like to call court and counsel attention to what has been debate stamped as 004 and 005.
And defendant, have you seen these items?
I have, Your Honor. I have no objection at this time.
Your Honor, may I approach the witness?
You may.
Ms. Donaldson, do you recognize the images in this composite?
Yes, I do.
And how do you recognize them?
Well, these are photos of the cut lock that was on the front gate of the Wild Wildlife offices and also the destroyed back entrance to Wild Wildlife.
And would you say that these are a fair and accurate depiction of both the cut lock and the back entrance to Wild Wildlife?
Yes, that's correct.
Your Honor, at this time, plaintiff would like to move into evidence what was pre-marked as Plaintiff Composite 1 for identification as Plaintiff Exhibit 1.
Any objection?
No objection, Your Honor.
So admitted.
I'm sorry, Your Honor. Your Honor, may we publish by way of screen share?
You may.
This is 004, the lock, and this is 005, the back entrance. Now, Ms. Donaldson, how did the defendant get into Wild Wildlife?
Well, like I said, the man she had with him, who I'd never seen before, was carrying bolt cutters, and it was very obvious that the lock was cut, so they broke in.
Objection, Your Honor. Speculation. May it be heard?
Yes, you may.
This witness has just testified that Karen Baja broke into Wild Wildlife. However, the witness did not see Karen break in and can only speculate that this is what happened. And therefore, we ask that the testimony be stricken from the record.
Response?
Yes, Your Honor. Your Honor, pursuant to Federal Rules of Evidence 701 for lay witness opinion testimony, a lay witness is able to give her or his opinion on things that they have witnessed for themselves. Prior to this testimony, this witness testified that she saw a broken lock on the gate of Wild Wildlife, and she saw the man that was with Ms. Baja holding lock cutters. It is a reasonable inference that they used those lock cutters to get inside of Wild Wildlife. She is the office manager, and she has been working there for 20 years, so she knows that the building is locked, and she probably locked it herself, Your Honor.
May it be heard, Your Honor, briefly?
You may.
As opposing counsel just stated, the rule for a lay opinion is when the witness has actually seen these events. The witness did not actually see Karen Baja physically break into the office, and therefore this is still speculation. And we ask that it be stricken from the record.
Sustained. That shall be stricken from the record. Please rephrase and proceed.
Yes, Your Honor. First one, Your Honor, may we preserve this exhibit for it to be used in closing statement?
You may.
So, Ms. Donaldson, we're going to move on from that question. Did you ever find anything else out about the disappearance of your father?
Well, yes. So the sheriff's office found his van at an airstrip about 40 miles away, and it was one that he never used. But inside, they found my dad's glasses and his keys.
You mentioned his glasses specifically. Was there anything significant about those glasses?
Yes, absolutely. So my father was blind as a bat, and he couldn't see anything without those glasses. But not only that, they were his only pair. He'd had the same pair since I was in high school, so I know he would never go anywhere without them, and he especially would never fly without them.
Now, Ms. Donaldson, was there anything else that you did personally in order to find out what happened to your father?
Yes, I hired a private investigator because I needed to know what happened to my father.
And who was this private investigator that you hired?
It was Taylor Pride with Pride Investigations Incorporated.
Now, I want to talk to you a little bit about your father and the defendant's relationship. If you could briefly describe their relationship.
Gosh, I mean, in one word, toxic.
Why would you say that?
They fought all the time. It was just constant.
Were there any fights that you were able to witness in particular?
Yes, there were many, but I mean, one in particular, I was at the wildlife offices and I heard my father and Karen arguing back and forth. And then all of a sudden, Karen just stomped out of the room, absolutely furious. And my father came out after her. It was because my father had told her that he wanted to file for divorce.
Now, were you able to speak with your father after that fight?
Yes, I was. And I tried to calm him down, but it was very strange because I'd never seen my father act that way before. Like, he was very visibly upset. So when I consoled him and asked him, what was really going on, he said that if anything were to ever happen.
Response?
I'm sorry, I didn't hear the objection, Your Honor.
It was hearsay.
Your Honor.
Your Honor, if allowed to testify this, she testifies in accordance to her statement, she will say that her father told her after experiencing an exciting event that if anything happened to him, it was the defendant who did it to him. Your Honor, this falls under the exception for hearsay for an excited utterance, 803-4.
Your Honor, may I be heard?
At this time, I'm going to sustain the objection, but I'd like to hear some more foundation before you try to introduce an excited utterance. Please try to rephrase.
Yes, Your Honor. Ms. Donaldson, could you describe this fight, what was going on with this fight prior to speaking to your father?
Sure, yeah. So like I said, they were arguing back and forth, and then all of a sudden, Karen just stormed out. She was visibly furious, and my father was really upset. And it turns out that Karen was so mad at him because he told her that he would be filing for divorce, and that's why she stormed out. So when my father came out and I tried to console him, that's when he started telling me about Karen.
And what was your father's condition when you were trying to console him?
I mean, he was very, very visibly upset in a way that I had never seen before. And like I said, I spent almost every day with my father. We were extremely close. I had never seen him like this before.
And Ms. Donaldson, when you spoke with your father, what did he say to you?
He told me that if anything were to ever happen to him, to make sure that the authorities look to Karen because she would be the one responsible. She obviously...
Speculation. May I be heard?
You may.
Whereas we agree that the first part of the statement may fall under the excited utterance exception to hearsay, that second part, that she will be the reason, she will be responsible for my death, is speculation. That's forward looking, and we ask that that part of the testimony be stricken from the record.
Yes, Your Honor. Your Honor, this witness is simply relaying a quote from her father. It is not speculation. She's not speculating anything. She's just relaying exactly what her father told her at that instance when he had that exciting utterance. These are just the words that came out of his mouth. This is not a speculation by this witness.
May I be heard, Your Honor?
That objection is overruled. We're going to keep moving.
Yes, Your Honor. Now, Ms. Donaldson, you mentioned that there were multiple fights. Were you ever able to observe any other fights?
Yes, one other one in particular that sticks out. My father had attempted to receive some sort of court protection from Ms. Baja because she was shouting death threats at him. Now,
Ms. Donaldson, let's go back to that lockbox that you mentioned earlier. What was it? What exactly was inside of that box?
That lockbox contained my father's last will and testament.
And do you have a copy of that last will and testament today?
No, I don't, because that morning that Karen took the lockbox from the Wild Wildlife offices, she was questioned by the police, but she said that they could only speak to her attorney. So she ended up leaving the premises with it, and she took all of its contents with her.
Now, did you ever inherit anything after your father disappeared?
No, because a few weeks after my father disappeared, Karen came forward with some document that she claimed was his last will and testament. And this document gave her absolutely everything.
What do you mean by everything?
Well, this document gave Karen all of my father's assets as well as his life insurance policy.
And do you know how much his assets and life insurance policy was worth?
Yes, his business was valued at $5 million and his life insurance policy was also $5 million.
So that was a total of how much money, Ms. Donaldson?
In total, Karen received $10 million, everything from my father.
Your Honor, may I have a moment to confer?
You may.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor. Ms. Donaldson, I want to talk about a very specific quote that you just said on direct. You said that your father told you that if anything should ever happen to him, to look into Karen because she will be responsible for his death, correct?
Yes, that is correct.
You claim this conversation was between you and your father, true?
Yes, that's correct. My father and I spoke after his argument with Karen.
Well, there were no other witnesses to this conversation, right?
No, it was just he and I in the Wild Wildlife offices.
So that's a yes.
Yes, ma'am.
Now, given that Lou is not here to speak for himself, we have to take your word for it that this conversation ever happened, correct?
Yes, ma'am.
So let's talk about when that statement was made. Now, you claim that that statement was made 2 weeks before your father disappeared. Is that right?
Yes, ma'am, that is correct.
So that puts that in early to mid-August of 2012.
Yes, ma'am.
And in 2012, when your father went missing, you never once told the police that your father said, look into Miss Baja, did you?
Not that I can recall, no, ma'am.
Ma'am, the investigation into your father's disappearance is still an active case, correct?
Yes, that's correct. However, they haven't investigated it as a homicide.
Well, it's a yes to my question that it's still an active case?
Yes, ma'am.
And at no point in time have you ever told the police what your father said about looking into Miss Baja?
Objection, Your Honor, asked and answered.
I'll allow it.
At no point in time have you ever told the police that your father said to look into Miss Baja, correct?
Not that I am aware of, no, ma'am.
So the first time in your entire life when you told someone about this statement was when you made your deposition in 2019, correct?
Yes, ma'am.
That's 7 years after your father disappeared. Isn't that right?
Yes, ma'am.
7 years after you claim that your dad made this statement?
Yes, ma'am.
So when you took that deposition, you knew some pretty specific things. For example, you knew that you were suing Miss Baja, correct?
Yes, I did know that.
And you knew you were suing her for $10 million, right?
Yes, and for the emotional distress that she has now caused me.
But ma'am, you stand to gain $10 million in this case. Isn't that right?
Yes, ma'am.
Now let's move on and talk about your father's will. Now, Miss Baja produced a copy of your father's will, correct?
Well, she produced what she claims is my father's will.
Well, I know that you're claiming the will was fake, but we can agree that she produced a copy of a will of Lou Donaldson, correct?
Yes, ma'am.
And the will that Miss Baja produced left all of your father's assets to her, true?
Yes, that's correct.
Well, you claim that your father had a different will.
Yes, his actual last will and testament.
And is that a yes to my question? You claim that he had another will?
Yes, ma'am.
And you claim that in this other will, you would get 25% of his assets.
Objection, Your Honor, best evidence rule.
Response?
Your Honor, may I be heard? During their direct, this witness testified about the other will, about her father's other will, and therefore we are allowed to cross on that information.
Your Honor, may I be heard?
You may.
Your Honor, during the direct examination, this witness testified that her father had another will. This witness never testified to what was the contents or inside of that other will, and therefore this is a best evidence rule violation because the defense does not have this will to prove what was inside of that previous will.
May I be heard, Your Honor?
At this time, I'm going to overrule that objection. I believe that the plaintiff has opened the door to this line of questioning.
Yes, Your Honor. I'm going to ask that question again. In this other will that you claim your father had, you would get 25% of his assets. Is that right?
Yes, ma'am. My father wanted to split his assets evenly 4 ways.
Well, ma'am, you never produced another copy of this will, did you?
No, ma'am. Like I said earlier, Karen Baja took it with her the morning that she was at Wild Wildlife.
Is that a yes to my question that you've never produced a copy of this will?
Yes, ma'am. That's correct.
And you don't know who the executor of this will was, do you?
No, ma'am. I don't know that information.
You don't have any witnesses that can testify that this other will ever existed, correct?
That's correct.
So we just have your word to take that this other will exists today, correct?
Yes, ma'am.
Now, I want to talk about how you responded to your father's disappearance. Your father disappeared in 2012, correct?
Yes, ma'am. That's correct.
And you talked about on direct how you guys were incredibly close, true?
Yes, we were extremely close.
Well, after your dad went missing, you never tried to call him, correct?
I am not completely sure of what my communication records were with my father. No, ma'am, I don't have any information regarding that.
Ma'am, you don't remember if you ever tried contacting your father?
I searched for my father extensively, and that's why I ended up hiring a private investigator because I knew that they would have more resources to look for him than I did.
Well, you don't have any cell phone records to prove that you tried calling him, do you?
No, ma'am, not that I can produce at this time.
You never tried to text your dad, did you?
I tried to reach out to my father. I looked for him extensively, but I don't have any physical documents that I can prove that to you with at this time.
Ma'am, I'm not asking how you tried to contact him. I'm asking specifically if you texted him.
Objection, Your Honor, asked and answered.
Your Honor, may I be heard? This witness is avoiding the answer. I'm asking a simple question as to whether she tried texting her father, and she's giving me this answer about the extent to which she looked for her father. That's not answering the question, and therefore I ask, and therefore it is not asked and answered.
Overruled. Please answer the question.
Ma'am, you never tried texting your father, did you?
No, ma'am.
It's been 8 years since your father disappeared, correct?
Yes, that is correct.
And over the past 8 years, you don't have any documents that you can bring to court today that show that you tried to contact your father. Is that right?
No, ma'am, not that I can bring to court.
Now, in 2017, you hired a private investigator, correct?
Yes, I did.
And that's 5 whole years after his disappearance. Isn't that right?
Yes, that's correct.
Well, in 2017, your father was declared legally dead as well, correct?
Yes, that's correct.
And $10 million was on the line. Wasn't that right?
Yes, ma'am. But it was more about trying to find my father at that point. I mean, I'd waited 5 long years and now he was declared dead.
Well, I know why you're claiming you're bringing this suit, but you would agree with me that in 2017, that's when the $10 million was at stake. Isn't that right?
Yes, ma'am.
Now, when your father was declared legally dead, Miss Baja got the $10 million. Isn't that right?
Yes, that is correct.
You didn't hire a private investigator until the same year that Miss Baja inherited your father's estate. Isn't that right?
That is correct. Yes, ma'am.
I want to move on and talk about the relationship between you and my client. Miss Baja was your stepmom, true?
Yes, that is correct.
Ma'am, you don't like my client, do you?
Well, we never really had any issues up until my father disappeared and she took over everything.
Well, in your own words, you hate my client, correct?
Yes, because I believe she is responsible for the death of my father.
Well, ma'am, let's talk about why you have to say that. If you don't say today that Miss Baja is responsible for the death of your father, you won't get $10 million, correct?
That's correct. But at the end of the day, my biggest loss is that I no longer have my dad in my life, and it's because of Karen. That's why I hate her.
So, ma'am, you would agree with me that you hate my client, correct?
Objection asked and answered.
I'm going to allow it, but just briefly.
Ma'am?
Yes.
Correct.
Yes, ma'am. Yes, ma'am.
And not only do you hate her, but you wish she were dead. Isn't that right?
I have said that before, but you have to understand how distraught I am over this.
Ma'am, is that a yes to my question that you wish she were dead?
Yes, ma'am.
And in your own words, you hope she is attacked and eaten by one of her tigers. Isn't that right?
Yes.
No further questions.
Any redirect?
Yes, Your Honor. Ms. Donaldson, how did you know what was inside of that lockbox?
Well, I kept that lockbox with my father's will.
The scope of cross.
Your Honor, may I be heard?
You may.
Your Honor, this witness went into the will. The will was found in the lockbox, and she mentioned that will specifically. This testimony was discussed during the cross-examination.
Ms. Fasano, I'm going to allow this, but just very briefly.
Yes, Your Honor. Ms. Donaldson, again, how did you know what was inside of the lockbox?
Sure. So I kept that lockbox in my desk at Wild Wild Life in the bottom drawer, locked.
And Ms. Donaldson, how long after your or the defendant took over Wild Wild Life were you fired?
Well, my father had disappeared on the 18th, and Karen Baja took over on Monday, the 20th. I'm sorry, I cut you off. My apologies.
My apologies as well. Objection, Your Honor. This was asked and answered on direct examination.
Response.
Your Honor, on direct examination, I asked this witness if she still worked at Wild Wild Life. She said no, that she had been fired. I'm asking her how long in between her Miss Baja taking over Wild Wild Life and her being fired. I didn't ask her the specific timeline.
Your Honor, if my memory serves me correctly, I do remember this question being asked during direct examination.
For purposes of foundation for our next line of questioning, I'm going to allow it.
Yes, Your Honor.
Ms. Donaldson, how long in between the defendant taking over Wild Wild Life were you fired by her?
Sure. So my father was declared missing on the 18th. Karen took over on the 20th, and I was fired right after that.
Your Honor, no further questions.
May the witness be excused by the parties?
Yes, Your Honor.
All right. I will move on to the next witness. The plaintiff may call their next witness, please.
Your Honor, at this time we call Taylor Pride to stand.
Mr. Pride, remember that you are still under oath,
Yes.
and please begin.
Good afternoon. Please, sir, introduce yourself to the jury.
Yeah, my name is Taylor Pride. Last name is spelled Pride.
Mr. Pride, before we get into why you're here today, I want to have the jury get to know you a little bit better. Mr. Pride, what do you do for a living?
I'm a private investigator. I own my own private investigating agency, Pride Investigations.
And have you always worked at your own firm?
No, I used to be a police officer. I was a cop for about 16 years before I started on my own.
And what type of cases would you investigate or look at while you were with the police department?
I ran kind of the gambit of cases, but I investigated a lot of economic crimes as well as murders, stuff like that.
You just mentioned economic crimes. What type of economic crimes would you look into?
The bulk of my work was centered around forgeries.
Okay, and was it necessary to have any specialized training to look into forgeries?
Yes, I mean, you have to have an understanding of handwriting analysis, as well as being accredited by forensic investigating national agencies and stuff.
And have you received any certifications?
I have received certification
And what?
from the from the American Board of Forensic Examiners.
No worries there. Now, Mr. Pride, what, if any, continuing education have you participated in?
So since I've left the force and started out on my own, I complete continued education classes every year, and every 4 years I have to renew my certification.
Very well. Mr. Pride, now that we've talked about what you've done outside of the courtroom, I now want to discuss what you've done inside the courtroom. Have you ever testified in court before?
Yes, I have. Since the year 2002, I've testified about 15 times, both for plaintiff and defense, as well as prosecution and defense for criminal trials.
And in what capacity have you testified as?
An expert in forensics and analysis, over 15 times.
Very well. I want to switch gears a bit and talk about why you're specifically here today. Why are you here today, Mr. Pride?
I was hired by Cam Donaldson to look into the circumstances of her father's disappearance, as well as the potential forged will.
And were you able to complete your investigations?
I was able to complete both of them, yes.
And without going into details, were you able to come to any conclusions on these investigations?
Yes, I reached conclusions in both of my investigations.
Now, was the evidence that you relied upon coming to these conclusions evidence that is usually relied upon by experts in your field?
Yes, it was.
All right. Well, Your Honor, at this time, we'd like to tender this individual, or I apologize, Your Honor, may we approach?
Right.
Your Honor, we'd like to tender this individual as an expert in the area of handwriting analysis and investigation.
Response?
Objection, Your Honor, pursuant to 702, may I be heard?
Yeah.
Your Honor, this witness has not given us any foundation as to prong C of Rule 702. We've heard nothing about the principles and methods that this expert witness used in coming to their conclusion today, and we've heard nothing as to the reliability of those principles and methods. Without that, it's not a qualified expert under Rule 702.
Response?
Your Honor, we have already established that ever since 2002, for 18 years now, this individual has been working with investigation, ranging from economic crimes, which is forgeries, something that is a material issue in today's case of whether or not a will is forged, as well as investigation going all the way to murder, which today we're a material fact that issue is whether or not Karen Baggio has killed Mr. Donaldson. Your Honor, if you would like, we can go into what this expert or what this individual has done specifically in today's case. And after we go into that, then we can tender them as an expert again.
Your Honor, may I respond?
You may.
Your Honor, I have no problem with this witness's tenure or expertise as in how long he's been doing this and what experience he has. My objection is specifically to prong C of Rule 702, the reliability of the principles and methods that this expert witness used in coming to their conclusion today. We haven't heard anything about what those principles and methods are, and we've heard no foundation as to the reliability of those principles and methods as required under prong C of Rule 702.
At this time, I'm going to allow the defense to voir dire the witness should they wish to challenge the propriety of his training. But right now I'm leaning towards admitting this witness. So, Mr. Nadavati, would you like to voir dire the witness?
Yes, Your Honor. May I make an offer of proof?
You may.
So we have no objection to this witness testifying as an expert in forensic analysis of the will, specifically the forgery aspect of the will. However, this voir dire will be focused on whether this witness is permitted to give his opinions on the validity of the investigation and the investigative techniques of the police. When it comes to this witness testifying as an expert in investigation or investigative techniques and giving his opinion on that, that's what we object to, and this is what that voir dire will be focused on.
I will keep that in consideration when we reapproach. You may voir dire the witness.
Yes, Your Honor. Good afternoon, Mr. Pride.
Good afternoon.
Mr. Pride, you haven't received any certifications from the Federal Bureau of Investigation in investigative techniques, have you?
No, I have never worked for the FBI.
Sir, when you were a police officer, you were never recertified after you went to the academy, were you?
No.
Sir, after you left the police academy over 20 years ago, you haven't gone back and taken any courses, have you?
No.
You haven't been recertified in any manner in investigative techniques since you left the police academy?
Just the handwriting and forensic stuff that I do now, but none of the police training, no.
That's right, sir. You haven't been requalified by any sort of education in investigative techniques, have you?
Outside of forensics, no.
Now, sir, I heard you right when you said on earlier in this direct examination, you have testified in court before as an expert, right?
Correct.
But every time you testified in court, you testified as a forensic document analyst. Isn't that a fact?
Objection, Your Honor.
That is.
We're
No
approaching.
one will allow it.
Mr. Pride, I'll ask the question again. Every time you've testified as an expert, you've testified as a forensic document analyst.
That is correct.
You've never testified and given your opinion in court on police investigative techniques. Isn't that a fact?
That's right.
Thank you, Mr. Pride. Your Honor, at this time, I re-raise my objection under Rule 702 as to this witness giving his opinion-based testimony on the police's investigative techniques.
Your Honor, may I briefly respond?
You may.
Your Honor, in regards, Your Honor, for an individual to be considered an expert, this is something that a lay person cannot give an opinion about, something that a lay person cannot opine on. The expertise and the experience that this individual has had in investigation with the being a detective, going into a police force for 16 years, this is more than just a lay witness opinion. This goes into expertise. Your Honor, in response to the Wadir point of this might be the first time that they testify as an expert in investigation. Your Honor, an expert needs to testify the first time at some point in time. They've testified 15 times as an expert in handwriting analysis. Your Honor, at one point in time, it was going to be his first time testifying. Your Honor, therefore, at this time, this individual should be tendered as an expert for handwriting analysis as well as investigation.
May I respond, Your Honor?
You may briefly, though.
Your Honor, we have no objection as to this witness being tendered as an expert in forensic document analysis, which is the handwriting analysis that this expert conducted. However, regardless of his experience, regardless of the fact that he was a police officer, Rule 702 makes very clear what the plaintiff has to lay in order for this witness to be tendered as an expert, specifically in investigative techniques. Not prong A, B, or C has been met. And pursuant to that, Your Honor, under Rule 702, he's not qualified to give his opinion-based testimony on investigative techniques. The 702 foundation just isn't there.
Unfortunately, I do disagree with that analysis. I think that the Mr. Tioso has actually laid a proper foundation for a strong history of experience with investigative work, and therefore I will allow the endorsement of this witness as both a expert in investigations as well as handwriting and signature analysis. If you would like to question him on your cross, you may do so to try to see if there's something there.
Yes, Your Honor.
Mr. Tioso, please move forward.
Mr. Honor. Mr. Pride, I want to talk about the two investigations that you briefly mentioned. Let's start with your analysis on Mr. Donaldson's alleged will and testament. What conclusion did you come about this?
So it was my opinion that the signature on Mr. Donaldson's will and testament that was provided was a forgery.
And what steps did you take to reach this conclusion?
So first I started off, I conducted a very thorough analysis into Mr. Donaldson's handwriting and coming to that conclusion.
Walk us through that analysis, Mr. Pratt. What was the first thing that you did?
So first I started off with, I guess, what the scientific community would probably call a control. So we pulled two signatures of his that were verified signatures, one from an ID, and we compared those to the signature that was on the will.
Your Honor, may I approach?
You may.
Your Honor, at this time, we would like to introduce this witness with those two samples. However, one of those signatures is from this temporary restraining order. Now, we have stipulated with opposing counsel that we have extracted that signature and placed it on a blank document. That blank document has the heading signature of Mr. Donaldson from restraining order. We can constructively redact that and just show that there are two signatures that this expert relied upon in coming to this analysis.
Mr. Nanavati? I'm sorry, you are still muted, unfortunately.
So it's our understanding that this is correct. We stipulated to this in pretrial and have no objection.
I will allow it, although I do not want the restraining order to be mentioned. So that redaction needs to also be made to remove the restraining order, but we can agree that that signature should be allowed.
Your Honor,
Yes, Your Honor.
I apologize. Your Honor, just to clarify, in that document, just for identification purpose, we wrote it. However, we have stricken through it, and we just ask that it be constructively redacted because we do intend on publishing this by way of share screen.
And for constructive purposes, obviously, we're limited by our technology, and I don't want to have to wait for you to do that. So let's go ahead with that.
Very well. Mr. Pride, have you had the chance to review what has been previously been base stamped as Exhibit 007 and 016?
Yes, I have. I examined both of those.
And how do you recognize these exhibits?
Yeah, so the first one is from an ID sample of Lou Donaldson. The second one is from a court document.
And are these signatures in the same or substantially same condition as the last time you saw it?
Yes, they are.
Your Honor, we now offer into evidence what has been previously base stamped as Exhibit 00, well, the signatures that have been base stamped as 007 and 016, and we offer them into evidence as defense exhibits 2.
Objections?
Plaintiff exhibit 2.
Without objection, Your Honor.
So admitted?
Your Honor, may we publish by way of screen share?
You may.
Mr. Pride, can you confirm once those two documents appear on your screen?
Yes, they are up.
Mr. Pride, or Your Honor, may you ask the jury if they can see these two samples?
I'm sorry. Can all jurors view these samples? I have to assume they can.
Mr. Pride, you mentioned that you analyzed these two samples. What did you notice when you did this comparison?
Yeah, so I mean, these samples are pretty identical, right? I mean, the person who writes these writes in a straight. They don't lift their pen a lot. That's something that we look for, is whether or not they're lifting their pen. This person doesn't lift their pen. But of note, as the name goes on and you get to the last part of Donaldson, there's what we call a lazy letter. In this case, it's a lazy O in Donaldson. At the very end there, you can see it kind of peaks at the top. And that's when somebody just is so comfortable with writing their name, it just becomes like a lazy letter. That's what we call it in the industry.
And Mr. Pride, just for the sake of presentation, just to clarify, you're discussing this O in Donaldson, right?
That is right.
And this O in this Donaldson, right?
Correct.
Mr. Pride, besides the individual letters in these signatures, what about the writing style? Were there any similarities there?
In the writing style, yes. I mean, they were written pretty much identically and the same way.
Okay. And how were they written the same way, Mr. Pride?
There's no pen lifts or anything to indicate that the person was not comfortable writing their own name. That's something that we look for to see if the person is comfortable in writing their name. And this person, whoever wrote the same one twice.
Now, Mr. Pride, after you analyzed these two samples, what was your next step?
So after we had the control down, then we went to the signature that was in question. And at that point, that's when I looked at the signature that was on the last living will and testament that was provided.
Your Honor, may we constructively approach the witness with an exhibit?
You may.
We now call court counsel's attention to what has been previously base stamped as Exhibit 14. This is the last will and testament of Mr. Donaldson. Mr. Pride, do you recognize this exhibit?
Yes, I do.
How do you recognize this exhibit?
This is the last living will and testament that I was provided to review.
And is this last will and testament in the same or substantially the same condition as the last time you saw it?
It is.
Your Honor, We now offer into evidence what has been previously marked as or bait stamped as Exhibit 014 as Plaintiff Exhibit 3.
Any objection?
Without objection, Your Honor.
So admitted.
Your Honor, may we publish this by way of share screen?
You may.
Mr. Pride, can you confirm once that will and testament is on your screen?
Yes, I can see it.
Now, Mr. Pride, what was the handwriting in question that you mentioned?
So under the signature block, there is a signature that says Lou Donaldson. That was the signature that I evaluated.
I'm going to go over with my cursor just to clarify. It's this Lou Donaldson that you're referring to?
That's right.
Now, after you compared the two samples and then you compared them to this signature, what did you analyze when you compared those two?
So when I put these signatures together, I looked for the pen lifts, like I talked about earlier, as well as the lazy letters, and just any indication if the same person who wrote the first two signatures wrote this third one.
And Mr. Pride, moving on past the signature, I now just want to talk about the language of the last will and testament. Did you have a chance to analyze the language of this will?
Yes, I did. That was also something that I looked at.
What did you notice when you analyzed this language?
I've looked at a few wills in the course of my years of investigating, and the language of whether I die or disappear was
Objection, Your
odd to
Honor.
me.
May I be heard?
You may.
Your Honor, this is outside of the scope of this witness's expertise. This witness was tendered as a forensic document analyst focusing on handwriting, and he was tendered as an expert in investigative techniques. For him to testify about the language of a will and his opinion on the language of that will, it's outside of the scope of his expertise.
Respond.
Yes, Your Honor. Your Honor, this individual is an expert in handwriting analysis and looking into whether documents are forged. Something that this expert takes into consideration to come up with this conclusion is the language of a will. This expert has testified that they've looked into economic crimes, more specifically forgeries in their past. They've looked at multiple wills in their past. And therefore, this is something reasonable that an expert can reasonably rely upon in coming to their ultimate conclusion that this will was forged.
I'd like to see a little bit more foundation on his experience with this before proceeding in this line of questioning. So I will sustain that objection temporarily. If you'd like to lay some more foundation, Mr. Tioso, you are welcome to do so.
I'll stop sharing the screen. Mr. Pride, in economic crimes, what type of document do you review?
So any type of documents that would relate to the crime specifically. So we do a lot of review of those documents. I have looked at wills in the past in the course of my investigations.
And when you review forgeries and documents, what things do you take into consideration, or what steps do you take?
So obviously the handwriting is a big part of it, but we also look to the actual context of the document and to see what type of language is inserted into it.
And Mr. Pride, is that something that you did? Is that procedure something that you implemented in today's, in your analysis of today's will?
It is, yes.
And Your Honor, may we approach?
You may.
We now believe that we have set the proper foundation and explained that this is something that an individual that looks for forgeries, they take into consideration the language of the will in order to come to a conclusion of whether or not a document is in fact forged.
Mr. Nadavati?
Your Honor, at this time, we have no objection.
Okay. You may proceed with your line of questioning.
Now, I just, in case the jury may have missed that or something, Mr. Pride, what did you notice when you analyzed the language of the will?
Yeah, so like I said, I've worked with wills before, and I have never, in the course of my career, seen the language, if I ever die or disappear. The or disappears part was what stood out to me.
Now, Mr. Pride, moving on past the will, I want to talk about the signatures that were found on this will, besides Mr. Donaldson's. Besides Mr. Donaldson's signature, who were the witnesses of this will?
Samantha Lane and Cara Beja.
I want to discuss each of those individually one by one. Let's begin with Miss Samantha Lane. Were you able to speak with Miss Samantha Lane?
I did interview her, yes.
What did you learn from Miss Samantha Lane?
So Miss Lane told me that she was actually basically coerced into signing this will. She said that Karen Beja said that if she didn't sign it, she
Objection,
threatened
Your Honor.
him.
Hearsay to the statements of Samantha Lane.
Response?
Yes, Your Honor. Your Honor, if this witness testifies in accordance to your deposition, they're going to explain, or they're going to testify that Samantha Lane stated that she was coerced into signing a will. Your Honor, this is an exception to the hearsay rule, as it shows that this is a statement that goes against interest. Samantha Lane is stating that she was coerced into signing a will. She in of itself is showing that she did participate in forging a legal document. And this sheds a light on her being in civil liability or criminal liability. Therefore, it's a statement against interest.
Your Honor, may I respond?
Yes, please.
Your Honor, it's stipulated in today's case that Samantha Lane is an unavailable witness. We have no way to lay the foundation or clarify anything about Samantha Lane's comments in this case. Your Honor, although experts are allowed to rely on otherwise inadmissible testimony when coming to their conclusion, Your Honor, experts aren't allowed to be used as a backdoor to hearsay. This is an out-of-court statement being offered for the truth of the matter asserted. And although counsel has cited this statement against interest exception, Samantha Lane isn't here to give us the foundation or anything to actually certify this as a statement against interest.
Your Honor, may I respond?
You may.
Your Honor, statement against interest is when an individual is unavailable. When looking at the stipulations that we have, the stipulations of the plaintiff of who they can call, the only individuals that we may call is Cam Donaldson and Taylor Pride. There's no mention of Samantha Lane. And therefore, this individual is not someone that was approved as a witness in today's proceeding. Therefore, this individual is unavailable, and this still stands as a statement against interest.
May I respond?
You may.
Your Honor, a statement against interest is only applicable if it exposes someone to civil or criminal liability. Samantha Lane was saying that she was coerced into signing a will. Your Honor, her being coerced into signing a will doesn't expose Samantha Lane to any civil or criminal liability. It's not a crime to be coerced into doing something. The person who coerced you is open to civil or criminal liability. Samantha Lane is not in this case. It's not a statement against her interest.
Your Honor, may I briefly respond?
Briefly, but I'm going to have to wrap up the arguments on this issue right after this.
Your Honor, with the statement against interest, or what doesn't place her any civil or criminal liability, it's not the coercion. It's the simple fact that she still went on and signed a will that was forged. She participated in a fraudulent document, a legal document, and that is what places her in criminal and civil liability. Therefore, this is a statement against interest.
May I respond one last time, Your Honor?
No, at this point, I do believe that it would potentially place her into criminal or civil liability for forging a document or for falsely certifying a document. Therefore, I will allow the question, but on a short leash. Please move on.
Mr. Pride, regarding Ms. Lane, what threats, what did she say regarding Ms. Baggio?
Yeah, so she said that she had been coerced into signing the will by Ms. Baja, stating that Ms. Baja basically threatened to feed her to the cats or something of that nature if she didn't sign.
I now want to switch gears and talk about your investigation on Mr. Donaldson's disappearance. What was your conclusion regarding his disappearance, Mr. Pride?
Yeah, so it was my conclusion that Karen Baja was somehow involved in the death of Lou Donaldson.
Let's talk about how you got to that conclusion. What evidence did you rely upon to come to that conclusion, Mr. Pride?
Yeah, so I reviewed some financial reports of Lou Donaldson. I also have some photographs that were attached to my reports of his vehicle and some airplanes and stuff like that. I also talked to some people about it.
Well, let's unpack that. Regarding the financial records, why did you look into financial records, Mr. Pride?
Well, I mean, mostly because it's part of my background. You know, I like doing it, but also because it's a good indication of whether or not somebody actually disappeared or died. In this case, Karen Baja, was claiming that he had disappeared and ran off to Costa Rica to be with another woman. So I needed to look into that to see if there was any indication in his finances that was accurate.
And based off your report of his finances, was that an accurate thing Ms. Baja stated?
Based off of my reports and what I reviewed, no, not at all. Not a penny was touched after he allegedly disappeared, and there was $100,000 left in his account.
And you also mentioned some photographs. Your Honor, may I approach the witness with an exhibit?
You may.
Your Honor, calling court and counsel's attention to what has previously been bait stamped as exhibit 13. Mr. Pride, do you recognize this exhibit?
I do.
How do you recognize this exhibit?
This is some of the photographs that I was just talking about.
And are these photographs in the same or substantially the same condition as the last time you saw them?
They are.
Your Honor, we now offer into evidence what has been previously bait stamped as exhibit 013 as defense exhibit 4.
Any objection?
Without objection.
So admitted.
Your Honor, may I share screen?
You may.
Now, Mr. Pride, what did you analyze when looking at these pictures?
Well, this was Cam Donaldson's glasses that were found in his vehicle. At this point, we were just looking for any indication of whether or not he did disappear or how he disappeared.
Now, Mr. Pride, what is his glasses being in his car? How is that relevant to today's case?
Evidently, I learned in my investigation that he relied on those glasses quite a bit. So the fact that they were just left there, it's fishy that somebody would just leave something that they need that much lying around.
Mr. Pride, based on everything that you reviewed, based on everything that you've heard in today's courtroom, how were Mr. Donaldson's sentiments towards Ms. Baggio the last months of his life?
From speaking to his family, as well as my investigation, their relationship was on the rocks, to say the least.
And now, in regards to the will that we've talked about, what did Mr. Donaldson give to Ms. Baggio?
In the will that I reviewed, he left her everything.
Want me to confirm, Your Honor?
Certainly.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor.
Please continue.
Mr. Pride, I want to talk to you about the handwriting analysis that you conducted in this case. You're a handwriting expert, right?
I am.
In this case, you were trying to determine if the signature on Mr. Donaldson's will was forged.
That is correct.
In order to do that, you compared the signature on the will to other samples of Lou Donaldson's handwriting.
Correct.
Specifically, you compared the signature on the will to 3 other documents, right?
Correct.
Mr. Donaldson's signature on a court document.
That's right.
Mr. Donaldson's signature on his driver's license.
Right.
And third, it was Mr. Donaldson's signature on a note he wrote to his daughter, right?
Yes.
Sir, we can both agree that in order to actually compare signatures, you have to be able to look at them, right?
That's right.
Mr. Pride, you did not bring a copy of the note Mr. Donaldson wrote to his child to court today.
No, only.
No, we approach.
You may.
Your Honor, we object to Federal Rule of Evidence 401. Your Honor, just the fact that he didn't bring one of the 3 samples that he already reviewed does not make a fact any more or less probable. Your Honor, he's already testified to 2 samples that he's looked at This jury has seen those two samples, therefore this is not relevant.
May I respond, Your Honor?
Sure thing.
First, I want to clarify that the bar for relevance is very low. Furthermore, this witness is a handwriting expert who, in part of his conclusion, looked at 3 samples of handwriting, and it's our contention that he didn't bring some of those samples to court for this jury to see. Your Honor, that makes the fact that this witness's conclusion is not reliable, and that's certainly relevant in today's proceedings.
That objection is overruled. You may continue with that line of questioning.
So, Mr. Pride, you did not bring a copy of the note Lou Donaldson wrote to his child to court today.
No, just the other 2.
So this jury will never be able to see what Mr. Donaldson's signature looked like on that note.
I don't know. Maybe somebody else has it, but I did not bring it. No.
So, sir, that was my question. I asked you whether this jury will ever be able to see the signature on the note that Lou Donaldson wrote to his child, and they won't, right?
I honestly don't know. If somebody else has it, they can bring it in, but I don't have it. No.
This jury won't be able to compare the signature on the note to the signature on the will.
I don't know.
Sir, you also did not bring a copy of Lou Donaldson's signature from his driver's license.
Yes, I believe we looked at that in my direct.
Sir, but that sample was brought by the defense expert, right?
Right, but it was what I relied on in my investigation.
But you did not bring a sample of Lou Donaldson's driver's license to court with you today, right?
No, I don't have one on me.
So out of the 3 signatures that you used for your comparison, you only brought one of those signatures to show to this jury.
I guess you could say that, yeah.
Now, as a handwriting expert, you could have compared Karen Baja's signature to Lou Donaldson's signature on the will, right?
It doesn't exactly work like that when somebody's copying another signature, but I guess I could have, yes.
So you could have done that comparison to determine whether or not Karen Baja forged Lou Donaldson's signature.
Doesn't exactly work like that, but I still could have done it, yes.
But you never even did that comparison. Isn't that a fact?
Yeah, it's not really something you would normally do.
So because you never did that comparison, you have no opinion on whether Miss Baja actually forged Lou Donaldson's signature.
No.
Sir, you mentioned on direct that in coming to your conclusions, you relied on some of Cam Donaldson's statements, right?
That is correct.
But you know that Cam Donaldson can't be trusted, right?
I don't agree with that statement.
All right, let's talk about that a little bit. For instance, Cam Donaldson has accused Karen Baja of breaking into a lockbox on August 19th, 2020.
Sure.
In fact, Cam Donaldson claimed that the police were present for this incident.
That's correct.
But sir, you weren't able to find any police reports about this incident, were you?
No.
None of the local police told you that this happened.
No.
You couldn't find a single eyewitness who claims to have seen this incident.
Other than Cam? No.
You can't even show this jury a picture of this alleged lockbox.
I was not there for that, so no.
The only person who says this happened is Cam Donaldson, and Cam Donaldson alone.
I guess so.
Sir, it's fair to say that you trust Cam Donaldson.
I trust her as much as any investigator would. It's my job to get to the facts, but I do take into consideration her opinions.
Well, that makes sense because Cam Donaldson hired you for today's case, right?
Well, of course.
In fact, Cam Donaldson also accused Karen Baja of destroying Lou Donaldson's original will, right?
That's right.
Sir, you've been in...
Your objection?
Your Honor, this is beyond the scope of direct. we never asked about the destruction of an original will. Therefore, this is beyond the scope of the direct, Your Honor.
Your Honor,
Response?
may I respond? This witness has just stated earlier in this cross-examination that he relied on Cam Donaldson's statements when coming to his conclusion. Your Honor, the plaintiff has tendered this witness as an expert in investigation. Pursuant to Rule 703, it's fair to cross this witness on these statements because they factored into his conclusion.
Objection overruled. Please continue.
Sir, I'm going to ask it again. Cam Donaldson has accused Karen Baja of destroying Lou Donaldson's original will, right?
Yes.
You've been investigating this since 2017, haven't you?
Yeah.
But in your 3-year investigation, you haven't been able to find a single copy of this alleged original will, have you?
No.
In your 3-year investigation, you haven't been able to find a single person outside of Cam Donaldson who even saw this document.
No.
Cam Donaldson hired you to find Lou Donaldson, right?
That's right.
I'm going to allow it. Please move on.
Sir, Cam Donaldson hired you to find Lou Donaldson?
Correct.
Lou Donaldson disappeared in August of 2012, right?
Correct.
Cam Donaldson did not hire you in 2012.
No.
Cam hired you
Honor.
in 2017.
Objection, Your Honor. May we approach?
You may.
Your Honor, if this line of questioning continues, and if this witness testifies in accordance to their deposition, we anticipate that they're going to go into the fact that they didn't start their investigation until 5 years later. Your Honor, this is unfairly prejudicial and will mislead the jury, as it will make them feel as if just because the investigation started in 2017, that it was an inadequate investigation, that this was an improper investigator that was hired for this. Therefore, we ask that this be struck.
Your Honor, may I respond? Your Honor, it's the defense's contention today that this is not a case about murder. This is a case about money. Your Honor, the fact that this witness was not asked to conduct his investigation until 2017, may I make an offer of proof?
I believe you can just continue with your objection.
This line of questioning seeks to show that this witness was not tendered as an expert by the plaintiff until after the will itself gave $10 million to Karen Baja. The prejudicial value of that does not substantially outweigh any probative value that these questions have. This goes to show that this expert wasn't contacted until $10 million was in question, which is a core issue of today's case.
Objections overruled. Please continue.
Sir, Cam Donaldson did not hire you in 2012.
No.
Cam hired you in 2017.
That's correct.
That's 5 years after Lou Donaldson disappeared.
Correct.
In 2017, Karen Baja received the entirety of Lou Donaldson's estate.
Yes.
In 2017, Cam Donaldson received zero of Lou Donaldson's estate.
Yeah.
So let me get this straight for the members of the jury. Cam Donaldson did not hire you to find her missing father until the year that Cam received zero of her father's estate.
Yeah.
Sir, I heard you right on direct. You think Lou Donaldson's dead, right?
He's been legally declared dead, but I also do believe he's dead.
So you looked into evidence surrounding Mr. Donaldson's disappearance.
Correct.
You weren't able to find Lou Donaldson alive.
No, I was not.
You weren't able to locate Lou Donaldson's body.
No.
No autopsy has been conducted in this case.
No autopsy.
You'd agree with me, sir, that investigators often want to know how someone died in a murder investigation.
Yes.
If Mr. Donaldson is dead, you don't know the cause of his death.
No, I do not.
You'd surely agree with me that a murder weapon is a key piece of evidence in any murder investigation, right?
It is.
You didn't find any murder weapon in your investigation, did you?
No.
The police did not recover any kind of murder weapon in today's investigation.
No.
Knowing the location of where somebody died, well, you'd agree with me that that's also very important to any murder investigation.
I guess.
If Mr. Donaldson is dead, you don't know where he died.
No.
Sir, knowing when somebody died, that's also very important to any murder investigation, right?
Well, we can kind of figure out when he might have died, but we don't have an exact date. No.
But sir, you'd agree with me that knowing when somebody died is very important to any murder investigation.
It is, yes.
And you just said you don't know the exact date of when Lou Donaldson died.
No, just sometime around August 18th.
Sir, but you don't know exactly when he died. Isn't that a fact?
That's correct.
Neither you or the police found any eyewitnesses who claim to have seen Lou Donaldson being killed.
That's right.
You'd agree with me that investigators often look for evidence of a physical struggle when they're investigating for a murder, right?
Right.
In this case, you found no evidence of any scratches on Karen Baja.
I started my investigation 5 years later, as you pointed out, so I wouldn't have seen scratches from 5 years ago.
Sir, the police found no evidence of scratches on Karen Baja.
To my knowledge, no.
Sir, the police found no evidence of any bruises on Karen Baja.
To my knowledge, no.
Sir, to your knowledge, the police didn't even find any evidence of a single injury sustained by Karen Baja.
Not to my knowledge.
The police have been investigating this since 2012.
Not competently, but yeah.
Sir, I'm not asking you what you think about the competence of the investigation. I'm just asking you about when it started. And it started in 2012. Isn't that a fact?
It did.
The case is still active today, right?
It's shelved, but it is active.
So it is still active today, right?
Right.
They've been investigating this for over 8 years, right?
I wouldn't say competently, but they have been investigating it for that amount of time.
So, sir, once again, I'm not concerned about what you think about the competence of the investigation, but they have been investigating this for over 8 years, right? You'd agree with me?
Sure, yeah.
And you know that to this day, Miss Baja isn't even considered a suspect.
No, not by the police department.
Thank you, Mr. Pride. I have no further
Of
questions.
course.
Let me redirect.
Briefly, Your Honor. Mr. Pride, you were just asked about these active investigations and you talked about how they weren't competent. Your Honor, Mr. Pride, how are these investigations not competent?
They just didn't actually really look into the murder. They kind of dismissed it right off the bat and didn't really evaluate it whatsoever.
What didn't they evaluate?
Anything, really. I know that Ms. Baja has a brother that's on the police department, and they just didn't look into it.
Objection, Your Honor. Pursuant to Rule 403, may I be heard?
You may.
This witness just implied that because Ms. Baja's brother is on the police department, they didn't properly investigate this case. He didn't give any evidence of why that may be the case. Because of that statement, pursuant to Rule 403, that testimony is substantially more prejudicial than it is probative.
Response?
Your Honor, what this witness just stated was that he knows that there was an investigation. Things that he reviewed in this case back were different depositions, different statements. One of these was of Ms. Baja's brother, who was an investigator or who works in the police department. They never said that because this individual was an investigation or because he was a police officer, that's why this was an improper investigation. He just simply stated that that's something that he looked at.
May I respond?
You may.
Your Honor, the witness just was talking about the incompetence of the investigation and said they didn't really look into it Miss Baja's brother is on the police force. Your Honor, he is implying that because Miss Baja's brother is on the police force, the police did not do their due diligence in investigating this case. That is substantially more prejudicial than it is probative, as this witness has absolutely nothing to back up that statement or implication.
I'm going to allow it. Please move on.
Mr. Pride, based on everything you reviewed, what did Mr. Donaldson state towards the defendant months before he disappeared?
How was he feeling towards the defendant before he disappeared? Is that your question? Based off of what I found out,
Your Honor, objection. This was asked and answered. The witness on direct said their relationship was on the rocks when asked this identical question about the state of their relationship.
Sustained. Please move on.
Mr. Pride, who else besides Ms. Baja benefited from this will?
Not a single person, at least the one I reviewed.
Moment to confer, Your Honor.
Granted.
No further questions, Your Honor.
Thank you.
Your Honor, I have no recross.
Thank you. I will excuse the witness at this time. Are there any motions to be, or does the plaintiff have any additional witnesses to call?
Yes, Your Honor. Your Honor, at this time, in accordance with stipulation number 4, we would like to read in some of the transcript of Exotic Bob.
Very well.
Your Honor, again, the defense is going to object as this is hearsay within hearsay.
It is a stipulation between the parties as written in the case pattern.
Your Honor, we ask that per the best evidence rule that the video be played instead of the transcript. It's important that the jury hears the demeanor, how Exotic Bob plays this off as it's almost as a joke. It's important for the jury to assess the credibility of this witness, which is always at issue at trial. And we ask that you require that the video be played so that the full effect of the statement can be heard per the best evidence.
Your Honor, have you heard?
Yes, you may. Response?
Your Honor, additionally, in the stipulation, it says that either the transcript or the video could be played. The video isn't required to have to be played. We can just read the transcript.
May I be heard, Your Honor?
You may.
Even if the stipulation doesn't require it to be made, the rule of best evidence would require the video to be played. As I mentioned before, the demeanor of the witness is extremely important in assessing his credibility during this statement, and therefore we request that the video is played so that the jury can fully assess the credibility of this witness, which is always at issue at trial.
I'm going to sustain it, but for our purposes here today, I will allow it to be constructively played, if that's okay to the parties. I know that Ms. Mateer had already volunteered that.
Yes, Your Honor.
So, Your Honor, am I able to read or?
Like I said, you can read it, but it will be constructively playing the video, if you will.
Yes, Your Honor. Okay.
We just request that for the record, this statement was made very sarcastically and very jokingly, and for the jury constructively to receive that type of demeanor.
Very well.
And Your Honor, I'll be reading the last paragraph on what we have as page 30, but it's Exotic Bob's transcript. Now at the end of the meeting, Karen Baja walked out of my office. She stopped suddenly and turned around, and she came marching back to my desk. And she leaned over and she looked me right in the eye and she said, "Exotic Bob," because that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kitties just like I did him." Then she turned around and she walked out of my office. And that's all I have to say about that. And that's it, Your Honor.
Would the defense like to read in any portions of this transcript as well, or play any portions of the video as we may be doing constructively?
No, Your Honor.
Thank you. Do the plaintiff have any other witnesses that they wish to call?
Your Honor, the plaintiff doesn't have a witness. However, may we approach?
You may.
Your Honor, we would like to call court and counsel's attention to paragraph 16 of the complaint. Your Honor, this paragraph alleges on August 18, 2017, the defendant filed a motion to have the probate court of Statesville to declare the victim to be deceased. Probate Court of Statesville granted the defendant's motion to declare victim as being deceased. Your Honor, the defendant has admitted to this allegation. We ask that you instruct the jury that these facts are admitted by the defendant and therefore no additional proof is required.
Response?
No objection, Your Honor.
It'll so be stipulated and instructed to the jury.
With that, Your Honor, the plaintiff rests, and may we have a 5-minute break?
I'm going to actually ask if there are any motions that need to be made at this time, and then we will take a very short recess.
No motions are going to be made at this time, Your Honor.
Okay, very well. In that case, we will take a short 5-minute break. I have 5:47 Mountain Time. We will come back here at 5:53.
Your Honor, before we dismiss, can I get a time check for plaintiff's case?
Will the timekeeper please chime in? Not sure who the timekeeper was on this one.
Your Honor, the timekeeper for the plaintiff was Taylor Pride.
Mr. Pride? Mr. Pride, you are muted.
Oh, can you hear me?
Yes.
I was not aware I was supposed to be timekeeper. I was not told about that whatsoever. I didn't get an email or anything about that.
All right, wonderful. And is there a timekeeper for the defendant?
Yes, Your Honor, the timekeeper for the defendant would be our expert witness, Chris Renard.
Mr. or Miss Renard, as it may be.
Yeah, Miss Renard.
I was not advised that I was supposed to be keeping time either.
Yeah, they did not tell us expert witnesses that we were supposed to be keeping time. We can for sure start doing that from here on out, but we were not informed of that at all.
And from a judge's perspective, I was very much informed that the parties would be keeping their own time through timekeepers. So as a result, I would ask that the timekeepers who we've already identified here just keep time from this point forward. Unfortunately, parties, we do not have a static time. I will try to urge the parties to keep moving along, but as long as you are keeping reasonable time, we will work with whatever we need to here.
Yes, Your
That's fair to the parties?
Yes, Your Honor.
Okay. In that
Judge,
case,
for clarification.
Sorry?
I was just going to ask, Your Honor, for clarification, I am assuming you would like us to stop for objections.
Yes, please. We will
Understood.
come back in 5 minutes here, so 5:55 Mountain Time. Please enjoy your short break. Have the parties all returned?
Yes, Your Honor.
Yes, Your Honor.
All right, very well. In that case, we will begin the defense's case in chief. Is the defense prepared to call their next witness?
Yes, Your Honor. The defense calls Ms. Karen Baja to the stand.
Ms. Baja, remember that you are still under oath as you took at the very beginning of this proceeding.
Yes, Your Honor.
You may proceed.
Good evening, Ms. Baja. Would you please introduce yourself to the jury?
Yes, my name is Karen Baja.
Where do you work?
I work at and I own Wild Wildlife.
What is Wild Wildlife?
Wild Wildlife is my pride and joy. It's an animal sanctuary dedicated to protecting and preserving tigers, lions, and other big cats. It's truly my pride and joy. I've become so passionate about caring for these animals.
Would you recognize a picture of Wild Wildlife?
Yes, absolutely.
Would you turn to the document bait stamped 18 and let me know when you're there? For the record, I'll mark this as Defense Exhibit A.
I'm there.
So what is Defense Exhibit A?
It is a photo of tigers sleeping at Wild Wildlife.
Is it a fair and accurate representation of the tigers at Wild Wildlife?
Yes, it is.
Your Honor, I offer Defense Exhibit A into evidence.
Any objection?
No, Your Honor.
Thank you. So admitted?
Permission to publish Defense Exhibit A?
You may.
Can you tell us what we're looking at, Ms. Baja?
Yes, this shows what Wild Wildlife looks like. These are two of our favorite tigers taking a nap.
You could take that down, Mr. Nanavati. Thank you. Karen, are you married?
Yes, I am. I'm married to Lou Donaldson.
How did you two meet?
Funny story, actually. I was hitchhiking one night along the side of the road all alone when along came Lou and he rescued me.
Were you both involved in Wild Wildlife?
Yes, absolutely. We ran it together. And I guess you could say as our love grew and as our marriage grew throughout the years, so did the business.
Ms. Baja, do you love your husband?
Yes, absolutely. I love my husband very much. He is my soulmate.
Was your marriage perfect?
No marriage is perfect. And I'll admit we had our ups and downs here and there, but as I said, at the end of the day, we love each other very, very much.
Do you know where Lou is today?
I so wish I did, but I do not know where my husband is.
And when was the last time that you saw your husband?
It was 8 years ago, August of 2012.
How have you handled your husband's disappearance?
I mean, how can you handle something like that? I've prayed and I've hoped every day that he would return home to me. But every day is just harder than the last. I just try to keep going.
Have you had any closure?
Yes and no. After 5 painful years, I went down to the courthouse and Lou was declared legally dead.
Well, Ms. Baja, what happened to Wild Wildlife when Lou disappeared?
I continued to run it on my own.
How were you able to afford that by yourself?
Lou did leave me some money so that I could continue on with our life's work.
Now, I want to talk about August 18th, 2012, the day your husband went missing. What happened that night?
Sure, I was at home taking care of some newborn tiger cubs that were born just a few days prior. And in the middle of the night, I realized that I needed milk and tiger formula, so I stepped out to go get that.
Did Lou go with you?
No, he did not.
Why not?
I don't know. I didn't really know where he was at the time, and the tiger cubs just really needed to eat, so I stepped out.
Well, is it unusual for you to not know where your husband is?
Unfortunately not. That's not unusual.
Why is that?
Well, Lou was a businessman, and he would have to take off on a moment's notice.
Do you know why Lou would have to ever leave on such a short notice?
No, not really. He was a bit of a secretive man. He would travel alone, take his planes all over the world to Costa Rica. He would even take fishing trips on his own.
Would you recognize a picture of your husband fishing?
Absolutely, yes.
Ms. Baja, would you turn to the document date stamped 10 and let me know when you're there? And for the record, I'll mark this as Defense Exhibit B.
I'm there.
What is this attachment?
It's a picture of Lou fishing.
Is it a fair and accurate representation of this picture of Lou?
Yes, it is.
Your Honor, defense offers Defense Exhibit B into evidence.
Any objection?
Yes, Your Honor. Your Honor, this exhibit is not relevant to today's case. It has no tendency to make any fact more or less likely the fact that the defendant caused the wrongful death of her husband.
Your Honor, may I be heard?
Your response?
Your Honor is well aware the bar for relevance is extremely low. And this picture, the plaintiff is alleging that Ms. Baja killed her husband. Talking about a picture about her husband is extremely relevant to show how much she loved and cared about him.
Your Honor, may I be heard?
You may.
Again, Your Honor, this is a picture of him fishing. She's not in the picture. It is not known that she took the picture. This picture has absolutely nothing to do with today's case.
May I be heard, Your Honor?
May.
Your Honor, if permitted to testify, this witness will tell you this was her favorite picture of her husband, and she's going to talk a little about it for the jury. It's extremely relevant, and therefore it should be admissible.
May I ask, Ms. Mateer, is there actually any prejudicial value to just simply this photo for purposes of identification?
Your Honor, the picture is of him from behind, so we don't actually see his face, but it's not an issue of prejudicial value. It's just that this picture is not relevant in today's proceeding.
In that case, overruled. It will be admitted.
Permission to publish Defense Exhibit B, Your Honor?
You may.
Can you tell us a little about this picture, Ms. Baja?
Absolutely. This is my favorite picture of Lou. I think it really embodies his spirit and paints him how he really was.
What do you mean by that?
Well, like I said, he was a bit of a secretive guy, kind of a loner, really.
Thank you, Mr. Nanavati. We can take that picture down. So let's step back. On your trip to get the formula on August 18th, did you run into any issues that night?
Yes, on my drive home, my car broke down around 3 a.m.
Did you call for anyone for help?
I did, yes. I called my brother, who is the deputy sheriff, but I didn't have my phone on me. So I flagged down a passing car and they let me borrow their phone.
Why did you call your brother?
Well, like I said, he's the deputy sheriff. I knew that he was awake and on duty that night, so I knew it would be no problem for him to give me a lift.
Now, I want to talk about some of the allegations that were made about you today, Ms. Baja. Pam Donaldson claims that you killed Lou. I have to ask, did you kill your husband?
No.
Well, Pam Donaldson also testified about your marriage. I believe the word Cam used was toxic. Well, is it true that you and Lou considered a divorce?
Yes, that is true.
Why?
In large part because Lou did have another woman in Costa Rica.
This 404, this information is substantially prejudicial.
Response?
Your Honor, the probative value is not substantially outweighed by the danger of unfair prejudice. Here, the plaintiff has told you in the plaintiff's case in chief, they have told you how Lou was going to file for a divorce. And one of the reasons that he wanted to file for the divorce is that he had a mistress in Costa Rica. That's relevant and that's extremely probative to the case at hand. If they are going to allege that Miss Baja killed her husband because he wanted a divorce, then it is extremely relevant and extremely probative to see another reason why Lou Donaldson may have filed for a divorce, and that's because he had a mistress in Costa Rica. And therefore, the probative value is not substantially outweighed by the danger of unfair prejudice.
Any response to that?
Yes, Your Honor. Your Honor, this information is highly prejudicial, substantially prejudicial, more than any probative value that it may have. This information about the fact that Mr. Donaldson may have or may not have had a mistress, because this information is only coming from the defendant, can likely confuse the members of the jury on what the actual issue is in this case. And that issue is that the defendant wrongfully caused the death of Mr. Donaldson. And therefore, this information should not be shared with the members of the jury.
I'm going to overrule the objection and allow that line of question to continue.
So, Ms. Baja, Can you repeat the answer to that question as to why you guys consider a divorce?
Yes, it was in large part because Lou had met some woman in Costa Rica.
So did Lou ever file for that divorce?
No, he did not. We were trying to work through things. We had been together for far too long to just throw everything away.
So when Lou went missing, did you ever tell the police about this woman in Costa Rica?
Of course, I told them about the woman. I told them about Costa Rica in hopes that they would potentially find him.
Now, another thing Cam has claimed is that you threatened Lou. So I have to ask you again, have you threatened your husband?
No, never.
Have you ever harmed your husband?
God, no, no.
So what about Exotic Bob's claim that you made threats to make him disappear like your husband, as he says?
Exotic Bob absolutely hates me. He blames me for why that he is in jail. He made that up just to get back at me. It's wholly untrue.
Lastly, Cam Donaldson also claims that you forged Lou's will. Did you forge that will?
No, I did not.
I want to talk about how Cam's family treated you. When you met Lou, how did his family treat you?
Poorly, to put it lightly. I don't think they ever accepted the fact that Lou loved me.
How has Cam treated you?
Like the rest of the family, poorly.
Can you describe specifically how Cam has treated you poorly?
Sure. After Lou went missing, Cam started to create vicious rumors and conspiracies about me.
Do you trust Cam?
No, I do not trust Cam.
Do you know how much money that Cam is seeking in today's lawsuit?
Yes, Cam is seeking every penny of the $10 million today.
Thank you, Ms. Baja. No further questions at this time, Your Honor.
Very well. Any cross?
Yes, Your Honor, but prior to cross, may we approach?
You may.
Your Honor, in the student's testimony, the defense attorney asked her if she ever threatened her husband. We have direct contradicting evidence that she did, in fact, threaten her husband. That is in the TRO that you previously recused during the MIL process. Are we able to use that information to rebut her testimony since she opened the door to that information?
Before Your Honor, may I be heard in response? Your Honor, on direct examination of Cam Donaldson, Cam claimed that Cam heard multiple threats and arguments between Ms. Baja and Lou Donaldson. Cam specifically mentioned how Cam heard her scream a death threat. Those were the exact words that Cam used. And therefore, we haven't opened the door about this TRO because we are just asking her this to rebut what the plaintiff said on their own direct examination.
May I be heard, Your Honor?
You may.
Again, Your Honor, this witness just made the claim that she has never threatened her husband. However, we have contradicting evidence from that was filed in this same court that the court is aware of and has judicial notice of, rebuting that claim.
One moment.
Again, I stand by my argument how this is going directly to rebut what was said during the direct examination of Cam Donaldson.
I'm going to lean towards leaving that out at this point. I think that it should have been asked on direct for anybody who has information regarding that. The actual court pleading regarding a restraining order, I will not allow in.
Yes, Your Honor. Your
Yes.
Honor.
I'm sorry, Ms. Mateer?
Yes, I was going to just say I'm ready to inquire.
Okay, please proceed.
Yes, Your Honor. Ms. Donaldson, I'm going to ask you, Ms. Baja, I'm going to ask you a couple questions about what was discussed during the direct. You mentioned that you met your husband while you were hitchhiking, correct?
That's correct.
You called him your Prince Charming.
Yeah, I would call him that.
And you called him that because he rescued you, right? And you two, you eventually got married.
Yes.
And Ms. Baja, we can agree that you came from a poor upbringing, right?
Yeah, I never really had much.
Right, but your husband was wealthy when you met him, right?
Yes, he had his fair share.
Now, let's talk about your marriage. You and your husband had problems in your marriage, correct?
We hit some bumps in the road along the way, yes.
Right. And you just testified that your husband asked or told you that he wanted a divorce from you, correct?
Yes, we discussed it. We considered it.
This was an issue that you all had in your marriage.
It was a discussion that we had.
Okay. Now, Ms. Baja, it's also your position that your husband, he signed a will on June 14th, correct?
Yes.
And he signed this will only a couple of days after you had that discussion about the divorce, right?
Yes.
And in that will, it said that you would inherit your husband's estate and everything if he disappeared, correct?
That's right.
And about 2 months after he signed that will, you reported that your husband disappeared, right?
I was not the one who reported him missing. No,
You weren't the one that reported him missing?
I was not.
Okay, Ms. Ms. Baja, and let's talk about what occurred after your husband disappeared, though. On the morning of August 18, 2012, you went to the store, right?
That's correct.
And it was around 3 o'clock in the morning?
Yes.
And on the way back from the store, your car broke down.
Yes.
So you called your brother to come and help you.
That's right.
Now, your brother, he's a sheriff's deputy, right?
Yes.
He actually works for the same sheriff's department that investigated your husband's disappearance.
Yes.
Now, later on that day, on August 18th, your husband was declared missing.
Yes, he was reported missing.
Right. And the very next morning, on August 19th, you went to Wild Wild Life, right?
Yes.
And you've been in this courtroom this entire time, correct?
Yes.
So you were able to see the other testimony here today?
Yep, that's correct.
Including Cam Donaldson's testimony?
That's right.
So we can agree that on that morning when Cam Donaldson arrived with the police, you had a box in your hand, correct?
No, Cam is lying about that.
Fair enough. On August 18, 2017, you had your husband declared dead, correct?
Yes.
And this was 5 years to the day that he was declared disappeared, or that he was reported missing, sorry.
Yes.
And after you had him declared dead, you actually inherited his $5 million life insurance policy.
That's correct.
And you also took over your husband's business, Wild Wild Life.
Yes.
And immediately after taking over your husband's business, Wild Wild Life, you fired his daughter, correct?
That is not the case. I did not fire Cam.
You did not fire Cam? So it is your testimony today that you did not fire Cam Donaldson?
That's my testimony.
And you took a deposition in this case?
I did.
And in that deposition, you signed an oath, or you said an oath to tell the truth?
That's correct.
And you signed the statement at the bottom of it?
I'm sorry?
You signed your deposition?
Yes.
Your Honor, calling court and counsel's attention to the deposition of Cam Donaldson. Karen Baja. I apologize, Karen Baja.
Please approach. What's your objection?
Withdrawn, Your Honor. I was going to object for improper impeachment under Cam Donaldson's testimony.
Okay, very well. Please proceed, Ms. Batir.
Yes, Your Honor. Your Honor, actually, I'm going to move on to another question.
Okay.
Ms. Baja, you also inherited your husband's estate, correct?
That's correct.
And that estate was worth $5 million as well?
Yes.
So you inherited a total of $10 million?
Yes.
Your Honor, a moment to confer?
You may.
No further questions.
Very well. Any recross or redirect, sorry?
No redirect, Your Honor.
Very well. This witness may be excused. Do you have any other witnesses to call today?
Yes, Your Honor. At this time, the defense calls Miss Chris Renard to the stand.
Very well. Ms. Renard, may I remind you that you are still under oath.
Yes.
Please proceed. Oh, you may proceed.
Thank you, Your Honor. Good evening, Ms. Renard. Can you please introduce yourself to the members of the jury?
Yes, my name is Chris Renard. Last name is spelled Renard.
What do you do for a living, ma'am?
I'm a death claims investigator for Summit Life Insurance Company.
What does it mean to be a death claims investigator for a life insurance company?
So when a claim is made on a life insurance policy, it's my responsibility to ensure that there's no fraud or foul play involved in that claim.
How do you look for fraud?
I use my skills as a certified forensic document examiner.
What does it mean to be a forensic document examiner?
So essentially, I compare samples of handwriting to determine whether handwriting is authentic.
What happens if you find a document to be inauthentic or forged?
So I notify the life insurance company that there is likely fraud or foul play involved, and then the insurance policy is then not paid out.
How long have you been doing this?
20 years.
What did you do before you started working for Summit Life Insurance?
So I actually worked as a forensic document examiner for the Statesville Bureau of Investigation.
Other than your work experience, do you have any education in the field?
Yes, so I got my BA from Summit College in criminology, and then I graduated from the Statesville Police Academy.
Do you have any certifications in the field of forensic document examination?
So I'm certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
After you were done with your education, did you participate in any continuing education?
Yes, so I have yearly training workshops, and then I also engage in a set of basic continuing education relating to forensic document examination and insurance claim investigations.
Have you ever been asked by the court to testify as an expert before?
Yes, I have.
Do you always testify for the defense as you were doing here today?
No, so I've testified as an expert 25 total times. One of those has been for the prosecution, and the other 24 have been on behalf of the life insurance company.
I want to move on and talk to you about today's case. How did you become involved?
So the life insurance company asked me to conduct a forensic investigation into whether the claim, Karen Baja's claim on Lou Donaldson's life insurance company, if there was fraud or foul play involved. So essentially they asked me to determine whether the claim should be paid out.
Were you able to reach a conclusion after conducting your investigation?
Yes, I was.
Before we get into that conclusion, I want to take a step back. What facts and data did you rely upon when conducting your investigation?
So I used a couple pieces of facts and data. I first analyzed statements made by witnesses involving Karen Baja's behavior. I also briefly looked into the police investigation involving Lou Donaldson's disappearance. I looked at Lou Donaldson's last will, and then I looked at multiple writing samples of Lou Donaldson.
Ma'am, was that enough information for an investigator such as yourself to come to a conclusion?
Yes.
What principles and methods did you rely upon when conducting your investigation?
So I use standard methods involved in forensic investigations, including a complete handwriting analysis on Lou Donaldson's signature.
Are those kinds of reliable means and methods used by experts in your field?
Yes.
Did you reliably apply those principles and methods to the facts and data of today's case?
Of course, that's my job.
Will all of the opinions you give here today be held to a reasonable degree of professional certainty?
Absolutely.
Your Honor, at this time, we offer this witness as an expert in forensic document analysis, qualified to give her opinion regarding the authenticity of the signature on Lou Donaldson's last will and testament.
Any objection?
No objection, Your Honor.
So admitted as an expert in the area of document analysis and signature comparison.
All right, ma'am, let's talk about your conclusion. What was the first step you took?
So I cross-examined Lou Donaldson's will with a sample of confirmed handwriting analysis samples belonging to Mr. Donaldson.
Which samples of Lou Donaldson's writing did you use?
So I used Lou Donaldson's signature on his life insurance policy, and I examined that with the signature from Lou Donaldson's driver's license.
What were you able to conclude when you compared those writing samples to the signature on the will?
Well, the signature on the will the comparison ultimately led me to believe that it was likely Lou Donaldson's genuine signature.
What do you mean it was likely Lou Donaldson's genuine signature?
So the evidence regarding the signature was inconclusive at best, but there were sufficient similarities that led me to believe that it was Lou Donaldson's authentic signature.
At any point during your investigation, did you find any evidence suggesting that the will may have been forged?
Well, there were certainly differences in the signatures. I don't contest that. However, they were sufficiently similar. The differences led me to believe that the evidence regarding the signatures was inconclusive, like I said.
So what does this mean in regards to your investigation?
It led me to believe that although there was a possibility of the signature being forged, there just wasn't enough evidence to make a definitive determination.
Did you review any other evidence suggesting possible forgery of the will?
So during my investigation, I did review a note that came from a Miss Samantha Lane.
Who is Samantha Lane?
She's a woman I interviewed because she allegedly witnessed Lou Donaldson's signature on his will.
So what did you talk about with Miss Lane?
So I confirmed the details of Mr. Donaldson's will.
What details?
So Miss Lane, when I initially investigated her, confirmed that she did in fact witness Mr. Donaldson sign the will.
Did you ever hear from Samantha Lane again?
After speaking with Samantha in person, about a month later, I had received a bizarre note from her rescinding what she had told me, basically stating that she had not in fact witnessed, that she was coerced into stating she had witnessed this signature.
Did you follow up with Samantha Lane?
I attempted to, yes, but ultimately she never returned any of my attempts at contacting her.
So you have a will that appears to be genuine, and then you get this bizarre note from Miss Lane. Did you do anything else to investigate Lou Donaldson's disappearance?
Yes, I did look into the police investigation very briefly.
Why did you look into the police investigation?
You know, I wanted to examine the entirety of the situation. It was my job to determine if foul play was involved, and it was just the next step in my complete investigation.
Were you able to find any evidence suggesting Miss Baja killed Lou Donaldson?
No, I really wasn't able to find much.
Your Honor.
I'm sorry, you're actually very, very quiet. Could you please speak more loudly?
Your Honor, can you hear me now?
Yes.
Your Honor, our objection is that this is beyond the scope of this individual's expertise. Now we're going into whether or not she killed Mr. Donaldson. This has nothing to do with forensic documents or handwriting analysis.
May I respond, Your Honor?
May.
Your Honor, this witness is a death claims investigator for a life insurance company. We've laid all of the 702 foundation for her to be able to give her testimony on this. And furthermore, this witness is not going to give any opinions about the police investigation. She's going to talk about the evidence she found and how it factored into her conclusion. There is no opinion that's going to be offered here. It's just fact testimony that was conducted over the course of her investigation.
Your Honor, may I respond?
You may.
Your Honor, it is opposing counsel that tendered this witness as an expert in forensic document and handwriting analysis. Nothing in this is there about death. Nothing in this is about whether or not Karen Baja killed her husband. Your Honor, this is beyond this expert's scope and expertise. Therefore, we ask that this question be stricken.
May I respond?
Very briefly.
Your Honor, we have laid sufficient foundation that she is a death claims investigator who analyzes wills. Furthermore, she's not going to give any opinion-based testimony on the police investigation. She's talking about how the police investigation factored into her own investigation, which, as the plaintiff's own expert did, used the same police report to analyze whether there was any foul play involved here, which is, as she stated, a crucial element of any investigation she conducts. I also just want to reiterate, there will be no expert opinion elicited about the police investigation. She's simply testifying to facts that factored into her conclusion.
Your Honor, may I briefly respond?
Very, very briefly, please.
Your Honor, this has the danger of misleading the jury. This individual has been tendered as an expert, and this individual going and stepping across that line and talking about the investigation, talking about Ms. Baja, whether or not she killed Mr. Donaldson, this is going to mislead this jury into taking these facts, into taking this testimony and mislead them to, just because this individual who has been tendered as an expert just in document analysis, that this makes it more valid and more probable that she did not kill Mr. Donaldson. Therefore, it is misleading. And once again, it is the opposing counsel that tendered them as expert in document investigation, nothing else.
Your Honor, may I respond?
No, at this time, I'm going to make a ruling. I will allow the questioning to continue, but I will not allow any questions with regard to conclusions outside of the handwriting analysis to be given by this expert. I will also tender a instruction to the jury indicating that this is an expert purely in the endorsed area and in no other area. Please proceed.
Understood, Your Honor. Ms. Renard, why did you look into the police investigation?
Ultimately, life insurance policies are not paid if we determine that foul play is involved.
So when you analyzed that police investigation, were you able to find any evidence of foul play?
No.
From your review, did the police find any evidence of foul play?
Objection, Your Honor. Once again, may we approach?
May.
Your Honor, this has nothing to do in regards to document investigation. This is going into the investigation of the police report. And now this individual is being used as a conduit for hearsay on what she heard from the sheriff's office.
Your Honor, may I respond?
You may.
Your Honor, that question fell solely under the discretion that the court just gave on that ruling. We're not asking her to give any opinions or offer any expert testimony as to the validity of the police investigation or what may have gone wrong with the police investigation or any opinion on whether Ms. Baja actually killed Lou Donaldson. We're asking her to just talk about the evidence she reviewed. There's nothing.
At this time, I'm going to overrule and ask the parties to move along. We are getting a little long in the time here.
Ma'am, from your review, did the police find any evidence of foul play?
To the extent of my knowledge about the police investigation, no.
What does that have to do with Ms. Baja?
Ultimately, I determined that Miss Baja was not charged with a crime and she wasn't even being considered a suspect in the active investigation.
So did you ultimately decide to pay out the life insurance policy?
I did. My ultimate determination was that the life insurance policies should be paid out to Miss Baja.
Thank you, Ms. Renard. I have no further questions at this time.
Mr. Tiuso, would you like to cross-examine the witness?
Yes, Your Honor.
Please proceed.
Good evening, Ms. Renard. Now, I know I've been having some technical difficulties. Can you hear me clearly?
I can for now, yes.
All right. Please, at any time, if there's any difficulties, please let me know. Now, Ms. Renard, I just want to discuss some things that were discussed during your direct. Let's talk about your opinion and more importantly, why you're here today. Ms. Renard, you work for Summit Life Insurance Company, right?
That's correct.
And you were asked to come to a conclusion on whether or not Karen Baja should be paid $5 million of life insurance payout, right?
Yes.
And your final determination was that it should be paid out.
Yes.
However, by paying out those $5 million, you and your company were able to avoid future costly litigations, right?
I'm not really involved with the legal functions of the company, but I assume so.
Well, Ms. Martin, we can agree that you're the one that said that you avoided costly litigations, right?
Sure.
Ms. Martin, before you even came to that conclusion, well, you had to review some items as you discussed in your direct, right?
Yes.
I want to go over some of those items. Regarding Mr. Donaldson and his disappearance, Mr. Donaldson, the last time he ever disappeared was on August 17, 2012, right?
That's my understanding, yes.
And he wasn't legally declared dead until August 18, 2017.
Yes, because life insurance policies can't typically be paid out until 5 years have passed from the alleged disappearance.
And so the defendant, she didn't have him legally declared dead until one day after that 5-year passed, right?
That's correct.
And not only that, but when he was declared legally dead, the defendant, well, she also asked for the $5 million payout that same day, right?
Yes.
And we can agree that you found that concerning.
In certain circumstances, it is concerning, but in this case, 5 years is a lot of time to wait, and some people just choose to file it after the 5 years is up.
Fair enough. Let's move on and talk about what you investigated in regards to the will and the samples. Ms. Renard, when you reviewed these samples, you took 3 different samples and put them together, right?
Correct.
And when you reviewed just the samples, when you compared those samples to each other, you didn't see any differences.
There were sufficient similarities.
Well, in your report, you stated that when you compared just the samples, the only thing you said was they matched.
Yes.
It wasn't until you compared those samples to Mr. Donaldson's handwriting, his alleged signature on the will, it wasn't until that point that you ever mentioned that there were differences, right?
Correct.
Very well. Now, Ms. Renner, besides the signatures of Mr. Donaldson, you also looked at other signatures on the will, right?
I did. I looked at 2 signatures.
Let's talk about Ms. Samantha Lane.
Okay.
You stated that Ms. Samantha Lane, she was a witness to that will being signed.
Yes.
And Samantha Lane, she told you at first that she did sign that will.
When I met her, yes. When I met her in person, she advised me that she did sign the will.
But then you received a letter stating that she had been coerced by Ms. Baggio, right?
Yes. A month later, I received a letter allegedly from Samantha Lane stating that there had been coercion involved.
Not only coercion, but in that same letter, she stated, I never saw Mr. Donaldson sign, right?
That's what the letter stated, yes.
Right, and we can agree that at the bottom of the letter was a signature.
There was a signature at the bottom of the letter, yes.
And that signature read Samantha Lane?
It appeared to be from Miss Lane, yes.
Right, and something that you established during direct, you compare signatures, right?
I do.
But you can't tell this jury that you ever compared Samantha Lane's signature to the other signature on the alleged will and testimony, right?
I can't say that I have, no.
When you tried to contact Ms. Lane, you weren't able to, right?
I was not able to get in touch with her the second time around, that's correct.
And when you try to confirm whether or not she was there, well, you went and spoke with the defendant, right?
I went and spoke with Miss Baggio, yes.
And Ms. Baggio, she was also acting as the witness?
She was another signature that was on the will, yes.
And when she signed as a witness, she was also the beneficiary, right?
Yes, but that's not illegal in Statesville.
No, but you can say it was your words that that's not always favored.
In certain circumstances, again, I can't make a determination on what the circumstance was in this case. It's sometimes, not recommended. However, it's not illegal, and therefore Ms. Baggio was not violating the law in doing so.
Right, and I understand that might be what you want this jury to hear. However, my question was simple, Ms. Renner. You stated that it's not favored to have a beneficiary sign as a witness. The answer to that.
Objection, Your Honor. The witness said that it's not favorable. She's already answered the question.
Your Honor, may I respond?
Overruled. Just please proceed with the question.
So we can agree that it's not favored.
Yes.
And when Ms. Baggio signed this will as a witness, she was the beneficiary of the will.
Yes, that's my understanding.
And just to simplify this, Mr. Renner, and I apologize, a beneficiary, that means someone who's going to benefit off of the will?
Yes.
And to be clear, she was the sole beneficiary of this will.
That's my understanding, yes.
Moment to confer, Your Honor.
Certainly.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Proceed.
Ms. Renard, why did that bizarre letter from Samantha Lane not factor into your final conclusion?
Ultimately, I was unable to reach Miss Lane when I tried to follow up with her regarding the letter, and therefore I was unable to verify the authenticity of the letter. And so it could not play a substantial role in my investigation.
So do you even know if Samantha Lane actually wrote that letter?
I don't. All I know is that when I spoke to her initially, she confirmed to me that she had witnessed the signature.
Thank you, Ms. Renard. Nothing further.
This witness may be excused. The defense may call their next witness.
Your Honor, at this time, the defense rests its case in chief, and we ask for a brief 5-minute recess before closing arguments.
Very well. It is now 6:36 Mountain. I will give until, let's go 6:41 Mountain time. And I'm just going to leave this running once again, so please just mute yourself and disconnect your video. Are the parties ready to commence closing arguments?
Yes, Your Honor.
Yes, Your Honor.
All right, please jump right on in.
Your Honor, prior to proceeding, the plaintiff would like to reserve 2 minutes for rebuttal.
And will your co-counsel be doing so, or will you be keeping track of that yourself?
I guess I could keep track of it.
I'm happy to keep track of it as well. It's just up to you.
Okay. I think my co-counsel can keep track of it.
I can keep track of it, Your Honor.
Please just chime in with a 2-minute warning. Just let her know. You may proceed.
Yes, Your Honor. May it please the court, counsel, members of the jury. At the beginning of this trial, we told you that in the jungle, there are rules. And those rules have to be followed in order to survive. No one was more aware of those rules or her interpretation of them than the defendant. A woman who has spent her life working with some of the jungle's most dangerous animals. The only rule for her, self-preservation. And when the privileged lifestyle she enjoyed was suddenly in danger of being taken away from her, nothing was going to stand in her way. Not a will, not a family, not a daughter. Nothing would stand in the way of preserving her way of life. She was cold, she was calculated, she was conniving, and she looked out for one person and one person alone, herself. Now, we made some promises to you at the beginning of this trial, and I want to make sure that you know we have honored those promises, that we have fulfilled our responsibility. In a few moments, the judge will give you the jury instructions with the elements of the case. These 4 elements that we have proved here today. And one of the first things that we proved to you was that Mr. Donaldson is no longer with us. And we brought you evidence to show that. But no evidence was more telling than the fact that the defendant admitted she raced to the courthouse to have her husband declared dead. She knew that he was dead because she did it. Now, the defense, they floated this idea around that a man with almost $100,000 in his account chose to leave it all behind. They want you to believe that he went to Costa Rica, that he just left without telling his daughter, the one person who had access to his accounts, his schedule, his will, everything, the one person that he trusted the most. They want you to believe that he left without telling her anything. And the second thing that we proved to you is that the defendant caused Mr. Donaldson's death. And we brought you evidence of just how toxic things were in the Donaldson home. But you wouldn't know that if you only listened to the defense's testimony. She said that they were a couple in love and that they were soulmates. But she couldn't deny that the evidence, it painted a completely different picture. It wasn't a fairy tale, not a fairy tale at all. It was a nightmare, ladies and gentlemen. The defendant, he wanted a divorce. He was Mr. Donaldson, he wanted a divorce. He was terrified of the defendant. He even warned his daughter that if anything ever happened to him, Karen, the defendant, was responsible. In his own words, he said that. And this set the defendant off. Now, the defense, they said that this case was about family disputes and money, and they were right. The defendant was living a good life off of her husband and his money, and it was all about to be taken away from her. And she had to act fast. And guess what? She entered into survival mode. The defendant forged a will that left out Mr. Donaldson's family and left all of his possessions to her. A will leaving an estate worth $10 million to the defendant, only a few days after he had asked her for a divorce. Talk about a change of heart, members of the jury. And we didn't just highlight the defendant's suspicious actions today. No, we brought you evidence, and we brought you an expert who examines forged documents, Taylor Pride. And he testified today that the defendant's will was forged. And he based that on his examination of Mr. Donaldson's known signatures. And we also brought you the witness to the will, a witness who said that she forged the will, that the will was forged against her own self-interest. And the defendant, she didn't just stop at forging a will, though. No, she had to make her husband disappear like that forged will said. And how do we know what she did? Well, you heard the defendant's own words today from Exotic Bob. She told Exotic Bob that she would do to him exactly what she did to her husband. She would feed him and Samantha Lane to her cats, just like she did Lou Donaldson. And the third thing that we proved to you is that our client, she suffered because of the conduct of the defendant. In an effort to cover up her tracks, you learned that the defendant broke into Wild Wild Life the day after her husband was declared missing. And she tried to brush this off and paint it as her doing nothing wrong. But you saw the broken lock. You saw the hole in the back entrance. Does that look like the behavior of someone who had nothing to hide? Someone who had a right to be doing what they were doing? No, members of the jury, it does not. This was a defendant doing what she needed to do to get what she wanted. And she didn't care who stood in the way. She was going to get rid of them. Like my client, who the defendant immediately fired after taking over Wild Wild Life. Like Samantha Lane, who has also mysteriously disappeared after coming clean about that forged will. And like Mr. Donaldson, who was afraid for his life and trying to leave her. Now, the fourth and final element, we proved that to you all today as well. It was the defendant's actions that caused our client's injuries and damages. The defendant, she had the motive, she had the means, and she had the opportunity to intentionally cause the death of Mr. Lou Donaldson. And she did just that. But no matter what the defendant thinks, this courtroom, her rules don't apply here. And members of the jury, we have proven all four of these elements. We've checked all of these boxes. And now I want to talk to you all about damages. In our system, you, to the extent possible, have the power to right this wrong. And how do you do that? Well, there's no doubt in my mind that if you could, you'd wave a magic wand and everything would be put back the way it's supposed to be. Mr. Donaldson, he would be running his business again with his daughter. But you don't have a magic wand, members. In our system, we restore, we even the score with money. And as inadequate as that may be, that's all that you have. And to help you evaluate this, I'm going to talk to you about what my client had. She had a father, a friend, a trusted companion. She had her dad. Her loss was and is profound, and it will always be with her. And we ask that you rightfully award her $10 million, which is the value of Mr. Donald's estate that was stolen by the defendant. We ask that you award her $1 million for the suffering my client endured from being wrongfully terminated from her job of 20 years that she shared with her father. And lastly, we are asking that you award her $2.5 million for the years of pain and suffering my client will endure because of the wrongful death of her father caused by the defendant's actions. That is justice. And anything less is just not. You cannot bring Mr. Donaldson back, but what you can do, you should. And what you should do, you must. You should use the evidence that you saw here today, the witness statements that you heard, and most importantly, you should use your own common sense to come to the only conclusion in this case, supported by the facts. When you go into that back room, you will receive this verdict form. And when you see this form, you should find the defendant, Karen Baja, liable for the wrongful death of Lou Donaldson. And you should hold her responsible for $13.5 million in damages. Find her liable because she is.
Thank you very much. Defense, would you like to make a closing argument?
Yes, Your Honor.
Oh,
May I?
sorry. Yes, it is defense. Please proceed.
This is not a case about murder. This is a case about money. A case about a daughter consumed by greed, growing to hate the woman who got the money. Even now, after everything pointing to the reality that no one really knows what happened to Lou Donaldson, Cam Donaldson still continues to blame Karen Baja. Cam continues to concoct baseless conspiracies. Cam continues to tell a story that simply doesn't match the evidence. And that's the problem with the plaintiff's case today. You see, it was their burden to bring you more than just a story. They had to prove it to you. And to do that, they had to prove, one, that Lou Donaldson is dead, and two, that Karen Baja's intentional or reckless conduct caused the death of Lou Donaldson. So let's talk about those one by one. First, the plaintiff failed to prove that Lou Donaldson is dead. Remember, members of the jury, the plaintiff is suing Karen Baja for wrongful death. But they are missing, and what they failed to bring you is the most basic piece of evidence necessary for a wrongful death action. There's no body. This is a wrongful death case without a dead man. Now, plaintiff also told you today that there are rules in the jungle. And they're absolutely right, but there are rules in a courtroom too. And in a courtroom, you cannot come in and blame someone for murder, accuse someone of murdering someone without proof. Now, to this day, Pioneer Police have never considered Lou's case a homicide. To this day, they have considered him a missing person. The Pioneer Police don't know what happened to Lou Donaldson, and no one else throughout this trial does either. But let's talk about the evidence that the plaintiff proves that Lou Donaldson is dead. They tried to tell you that you know Lou Donaldson is dead because Karen Baja had him legally declared dead. But the truth is, this is nothing more than a piece of paper. A piece of paper that says when someone is missing for 5 years, that person's property gets to be distributed. All this document tells us is that 5 years after the disappearance of her husband, Miss Baja wanted closure and to move on with her life. Now, even if you believe, if you find that the plaintiff failed to prove that Lou Donaldson is dead, that's it. Case is over. You don't have to look any further because they have failed their case. However, even if you believe that there is evidence suggesting that Lou Donaldson is dead, that does not mean that they have proven their case. Because remember, they have to prove the second part of Cam's story. The part that Karen Baja killed Lou Donaldson. However, we know that they have failed in that aspect as well. Consider all the questions that we still cannot answer. If Lou is dead, when did he die? Where did he die? How did he die? When? Where? How? Those are all questions questions that the plaintiff failed to answer. Those are all basic questions that are needed to be proven in a court of law in order to prove a wrongful death action. And that is something that they simply could not do. Now, they brought to you a man named Exotic Bob today, and you got to see his demeanor, how joking he was, how sing-songy he was. But don't forget, Exotic Bob blames Karen Baja for why he's incarcerated. Exotic Bob, of course, would say anything to get back at Karen Baja. Now, you may be wondering, well, without any evidence to prove that there's a murder, why are we here today? And the answer is simple. We are here because Cam Donaldson wants $10 million, or rather $13.5 million. And this was her chance of getting it. Now, Cam chose Karen because Cam was angry that Karen got the $10 million. Cam was jealous that she didn't get a single dime. But Cam shouldn't be angry with my client. You heard today how it was Lou Donaldson's own choice to leave that money to Karen Baja, how he wanted to leave that money to see and trusted her that she would keep the animal sanctuary going. And members of the jury, that's exactly what she did. But members of the jury, I want you to remember something. You also heard that Cam waited to hire a private investigator until 5 years after her father went missing. And suddenly she had a story that her father said to look into Karen. And members of the jury, you heard that Cam didn't mention this story until she was deposed in 2019, until $10 million were at stake. If this were more than just a story, don't you think that she would have told the police this to assist in the investigation, to help find her father? Instead, Cam waited until there was money on the line. But that's not the only story Cam told. Cam told you a story that Karen Baja broke into the lockbox and took Lou's will. Members of the jury, remember my cross-examination and remember the cross-examination of the expert that Mr. Nanavati did. You didn't hear any evidence of a police report. You didn't hear any evidence of an alarm going off to document that incident ever occurred. You didn't see any hard evidence that that incident didn't occur, and you heard no other eyewitnesses. The only person who told you that that incident occurred is Cam Donaldson, and that's because it just never happened. No report, no hard evidence, no break-in. Now, when that story didn't work, Cam moved on and tried to tell you that Lou Donaldson's will, the real will that you saw in court today, she tried to tell you that that was forged. And you heard from two different witnesses today that spoke onto the validity of the will. Now, you heard from plaintiff's expert Taylor Pride first, and he told you that the will was forged and the proof was in the handwriting. But let's remember what you heard on cross-examination, that Taylor Pride only brought one of his own signatures. The rest of his report, he tried to pass off as his own, but was taken from Chris Renard, our expert's report. You also heard how Taylor Pride failed to compare the handwriting on the will to that of Karen Baja's, and didn't even produce the copy of the note that he claims he compared the signature of Lou Donaldson to. This note that he claims supported his evidence that proved his case. Now, members of the jury, don't you think that if this evidence was relevant to prove their case, if it did prove their case, they would have shown it to you? But you didn't see any of that today because the will wasn't forged and the plaintiff knows it. You heard from our expert today, Chris Renard. As an employee of a life insurance company, it's her responsibility to find a reason not to pay out that life insurance money. However, you heard her testimony. You heard how she didn't try to over-exaggerate things. She told you that her investigation was inconclusive. And yet, the insurance company still paid out. And lastly, the plaintiff tried to tell you that you know the will was forged because of a Samantha Lane. Members of the jury, the Samantha Lane story is a bizarre mess. And sure, Chris Renard maybe could have looked and done a better job looking into what happened to Miss Lane. But at the end of the day, this is simply another unknown, which is what the plaintiff's case, their entire case is built upon, unknowns. What we don't have is proof. And proof is what you need under the rules of the court. Now, in a moment, opposing counsel is going to come before you and they're going to have the last word. And I'm not permitted to respond, but I want to leave you with this one final thought. After sitting here today, you know that this is not a case about murder. This is a case about money. And no amount of plaintiff's anger or jealousy or hatred can make Miss Baja a killer. Find Karen Baja not liable.
Ms. Mateer, your reserved time.
Yes, Your Honor. May I inquire?
You may.
Members of the jury, the defense, they said that this was a case about a family dispute, and they were right. But it wasn't a family dispute between my client and the defendant. It was a dispute between the defendant and her husband. Her lifestyle, her financial well-being was being threatened, and she entered into survival mode. She had to do what she could do to protect her place in life, and she did just that. It was the defendant who had her husband declared dead. And the defense, they said that this was just a piece of paper. But what the real piece of paper was that forged will. The forged will that separated the defendant from $10 million, from all of her husband's money, so that she can continue to live her privileged lifestyle. You saw that today on that stand. Members of the jury, the defendant is responsible for the death of her husband, her own ambitious needs. Her need to preserve her life is what caused her to commit this crime, her financial well-being. And that is why we ask you to find this defendant liable for the wrongful death of Mr. Donaldson and to find her responsible for paying that $13.5 million in damages to our client, Cam Donaldson. Find her liable because she is. Thank you.
Thank you, parties. That concludes the evidence and presentation for this case. I wish you all the very best of luck as you go forward. And I want to thank everybody for being so professional and giving a wonderful presentation today. Any questions for me before we end?
Thank you, Your Honor.
All right.